Dear ladies and gentlemen, let's start our dialogue. Dear participants, I'd like to welcome all of you here to the IP Dialogue event, Intellectual Property Dialogue. So, initially, this format is proposed in the format of the round table, and now not all the participants are there in the hall. I understand that there are traffic jams, and furthermore, there are many people who are registered online, and this format is very close to the conference format. So, we will have coffee breaks. The lunch is not provided. So the ones who want to have lunch, please, you will have to search for the restaurants in the neighborhood of this building. There is also Wi-Fi, and somewhere on the postcards you can see where the Wi-Fi password is. So I would like you to switch off your mobile phones and turn your mobile phones into silent mode. So we also have the online broadcast in YouTube at Paragraph Urinform website. There will be a big conference, and the questions can be asked in Telegram box, and the QR code is provided. You can connect there. The links have been sent to you earlier with the final agenda. And the ones who haven't become speakers, but the ones who want to be the speaker, our program is pretty intensive and it has more participants than expected. Please send me your presentations and we will publish them in relevant topics dedicated to the IP Dialogue event. And now I would like to tell you the following thing, that we have a free talk format. The free talk, free presentation of the speaker, and then the discussion. However, there is a special Q&A session after your talks. We will not be able to answer all your questions immediately, but we will collect them, we will systematize them, and all the questions will be answered in any case, except for those that have to do with the specific case studies. The overall questions for intellectual property, yes, as well as the objectives with the specific clients, no, because there are some matters of confidentiality and interest, so we will not be able to do that. It was also supposed that the in-person presence will be also attended by the Justice Vice Minister, as well as the Director of the Intellectual Property Department of the Ministry of Justice would be there, but this meeting did not take place. And here we would like to welcome Kisibaeva. Apologies. The Department of Justice, Kisibaeva Belina Tokambaeva. She will speak on her personal capacity and on behalf of the Department and the Ministry of Justice in general. Please, the floor is yours. Dear participants of the meeting, today I'm privileged to welcome you and to speak on behalf of the Ministry of Justice. I represent the Department of the Ministry of Justice in Almaty, and we are the territorial body of Ministry of Justice, and we preserve all the functions on the territory of the city, especially with respect to the intellectual property rights protection. All the authorities of the Ministry of Justice are exercised in Almaty city. Dear participants of the meeting, on behalf of the Minister of Justice, I'd like to welcome all of you here at our today's event. And before I proceed, I'd like to express my gratitude to the host of today's event for their active involvement in the development and evolution of the intellectual property rights in Kazakhstan, as well as for the interest in addressing relevant issues in this sphere. The intellectual property rights in Kazakhstan in particular, fighting with the counterfeit products, as far as we understand, are the relevant matters in the sphere. And the illegal use of the intellectual property items is the part of the shadow economy, and the fair entrepreneurs cannot make competition to those who are engaged in the illegal activities and in car costs. Moreover, the government loses the profits because the illegal trade is not subject to the taxes, not taxable, and the information is distorted, and the market is overfilled or flooded with illegal products that create the threat and the risk for the health of the population. You know, one of the priority objectives of the Ministry of Justice is to form the governmental policy and overall coordination of the efforts in the intellectual property rights. And this work is aimed at further development of the intellectual property sphere, including the improvement of the legislation, the digitalization of services, strengthening the coordination of the stakeholders on the governmental level, international cooperation, professional capacity building, expanding the capabilities and skills of the employees, and the improvement of the legislation and outreach work. Our department is paying a particular attention to the matters of the intellectual property rights protection and preservation, and fighting with the intellectual property rights violation is done by the Ministry of Justice along with the territorial justice body, like I already mentioned, with the law enforcement agencies, with the custom authorities, as well as the economic investigation bodies of the anti-monopoly bodies. Fighting with fake products requires the adoption of comprehensive measures, not only from the part of the state authorities, but also from the business entities and our citizens. I believe that all of us should aspire to the elaboration of the efficient and comprehensive approach in fighting with the violations of intellectual property rights, ensuring the protection of the rights of right owners, and capacity building and outreach in this sphere. So I'd like to mention that the Ministry of Justice is open for further discussions of the issues related with the intellectual property rights protection. We are ready to take in mind all the proposals for innovations, creativity, and the development of new products and services to improve the system of the protection of the intellectual property rights. I hope that our today's event will contribute to the development of new methods, of new ideas, and new initiatives in addressing relevant issues in the intellectual property rights for preventing and impediment of the counterfeit products spreading. I'd like to wish you every success in today's event. Thank you very much. Thank you very much, Mr. Gambaeva. I'd like to thank the Ministry for their involvement, for the support of our event, and I would also like to give the floor to the representative of INTA. INTA is the international organization, as far as you know, the biggest association for trademarks. More than 10 members in this organization from almost all countries of the world. And now the floor is given to Mr. Tan Tien Dumde. He's the head of the INTA department dealing with the European countries and links with the government authorities and interdepartmental organizations who contributed a lot to the organization of this event. Mr. Tat, you're welcome.
Good morning. I hope I'm audible in the room. Thanks so much for this kind invitation. First of all, I would like to thank our host, Bolotov IP, the entire team there, Zanat, who've been working closely on this project. Thanks so much for your support. I would also like to thank, the next speaker, Dmitry Markanov, for his support as well. And last but not least, I would like to thank, the local authorities for their time, because we know how busy they are and they are being, invited to various events. We really appreciate that. Thanks to all the participants. It's really a pleasure. I wish I was there in the room with you, but due to personal reason, I was not able to join you, but hopefully next year we are going to have the opportunity to meet again, to meet in person. Thanks. Having said that, the International Trademark Association is a private sector entity comprising of more than 34,000, representatives, as well as, brand owners. In our daily work, we work closely with government officials, IPOs. We work closely with sister IP organization in improving the landscape of intellectual property with a specific focus on trademarks. Having said that, our work is done thanks to our members that are located in various parts of the world, almost in every territories. You will notice it today. We have members from Latin America, participants from Europe, so on and so forth. They are the lifeblood of the association. We also work with them in providing policy guidance as well as capacity building, training of examiners, training of custom official, so on and so forth. And this is done closely with government officials and other entities. Today, I'm here on behalf of the INTA, representing the Europe office, from where we are not only covering the European Union, but as well as other countries, other jurisdictions. So that's why it's with a pleasure that we are here in Kazakhstan, working closely with our local members as well as the local authorities. In this regard, we welcome the invitation from the Intellectual Property Office to build stronger ties as well as to identify potential ways of collaboration. We thank you. I wish you all a successful meeting, and we'll be available to answer any question we may have. And we thank again all of you for your time and your participation. Thanks so much.
Thank you, Ted. Thank you very much for staying with us. That's a great pleasure for us to hear you, and I hope that you will be able to stay with us at least along the whole event. And now I would like to hand it over to Dmitry Markanov. Dmitry, he's a managing director of one of the leading Russian firms in intellectual property rights. He's the active member. Good afternoon, Yuri. And the floor is yours, Dmitry. Good morning, Yuri. Thank you very much for inviting me here, and I'd like to thank all those participants who joined us today. That's a real pity that I can't join you personally, but I will be holding this event annually, and we will be able to meet each other next time. So if you allow me, I would like to start the screen sharing, and please confirm that you can see the presentation. You can see my slides. As I see that everything works well for you. Okay, thank you. I will start sharing the screen now. So I would like to introduce myself again. My name is Dmitry Markanov. I'm the head of the committee of the counterfeit products combating in Central Asia. And if you allow me, just very briefly about INTA and the activity of our committee. And I'm really, I hope that you will get interested in both in INTA and our committee. And probably this year or next year, you will join our committee. You will join the most active professionals in counterfeit products fighting. INTA is the largest association of professionals of intellectual property rights protection. It brings together more than 6,000 companies, and around 30,000 members from different countries. The association is the global one. It covers more than 180 countries, and this year, in general, the association exists for a long time and has been. It was founded in 1878, but one should know that the association was created on the basis of American patents, and then it turned into the International Association, and now it is one of the largest ones. When it comes to the work of the association, that's clear that the association has the employees that are working on a permanent basis, and there are also members who attend the work of the associations, and the work of those members is organized within 19 INTA members. Who are those members? These are the legal experts of the large legal companies. These are the lawyers of brand owners. These are the legal experts and inspectors for the trademark protectors and right users. So the biggest and I believe the most important committee in INTA is the Committee on Fighting with Counterfeit Products, AACC. It is as big as within the committee we have 9 regional subcommittees. You can see them on the slide. The largest ones is the US and China. From my side, I also call on all of you colleagues to join INTA, to join the work of the committee in our region. There are many interesting things and many very fruitful activities. In addition to 9 subcommittees, we also have 3 global project teams that brings together the members from different regional subcommittees, and all of them are engaged in the global detailed studies of specific areas, especially when it comes to regions. We are working with businesses, we are working with the local executive authorities, we hold conferences on a regular basis, we attend the events, we work out different moments related to the trademarks protection. When it comes to the global teams, we have 3 main teams. The team combating the online infringements, and the second one is the team for organizing inter-departmental and inter-political dialogues of combating the counterfeit products, and the fresh global team is the team for the efforts coordination with the custom bodies. So here you can also see that the priorities for 2022-2023 for our committee globally were the following things: the fighting with the online infringements, and the reason for that is the following: because today through internet one can sell a great number of fake products, and that's really important work to cooperate with marketplaces, because only cooperating with marketplaces we can fight with counterfeit products. And that's going to be our afternoon section, and I invite all of you to attend it, and the representatives of marketplaces will share their best practices of fighting with the fake products. And another important aspect of the committee work is the transboundary infringements, because we understand that counterfeited products is not something that you produce and sell in one country. Normally, when you manufacture something in one country and sell in a different country, passing 5 or 6 countries at the same time, that's why transboundary control and activities are the priority for INTA. Furthermore, you can also check that our priority in here is the provision and work with custom authorities, provision of information as well as trainings, and the focus on the newest technologies that may help you in fighting with counterfeited products. So when it comes to the documents handling in INTA and the developments that we are creating here, you can see the affordable resources for INTA that can be used in day-to-day practice. And I would like to mention that such documents as the overall INTA recommendations, despite the fact they are not the regulatory documents, but nonetheless they are accepted by the European courts, the US courts, and others as the construction of the law for us to understand what the legislator meant and how this or that area is being regulated. And that's why the members that are engaged in INTA's operations have access to those documents and have a chance to contribute the drafting process of such documents and to create documents that fairly defend the rights of the intellectual property owners. And when it comes to the objectives of our committee, this year we had two big goals: to hold the dialogue fighting with the IP policy dialogue, fighting with counterfeit products in Turkey and in Kazakhstan. And I'm delighted, colleagues, that here in Kazakhstan we have this IP policy dialogue. And I would like to express my thanks to Yuri Bolotov, to Yuri Jusan Mart, and others who contributed a lot of efforts and powers in organizing this event. Just recently we have had a big dialogue in Turkey, attended by the management of INTA as well as the representatives of Turpatent and other departmental bodies. You can also see that we are investing in the holding of educational programs. We want to cooperate with universities and educational institutions, explaining that buying fake products is not a good thing, because you can only win the fight when the consumer rejects buying counterfeited products, because the fake manufacturers will always find ways how to deliver these products to the end users. So we have already done a big work for revealing the pathways of fake products, and our department has done a great work in this respect, and we have tracked the pathway from China to Europe through warehouses and ports, and we are really thankful to the representatives of the committee, and it's a great pleasure when I see that many people are involved in this process and they involve their GR services, safe security teams, and thanks to donors we managed to make it happen. On that, I would like to conclude my INTA's presentation, and the Committee on Counterfeit Products Combating. I would like to call on all the participants of the conference, both online and offline, to explore the opportunity of joining INTA, because INTA is a community of professionals, the global community that allows all of you to keep pace with the development of international law, to take part in the best possible conventions, and Yuri will confirm that INTA's conventions are the most fruitful and the most reachable, are the richest ones, and our next conference will take place in Atlanta this spring, and I would like to invite all of you there, and we will be happy to further cooperate with you. Yuri, thank you very much. Thank you very much, Dmitry, for your presentation. Thank you very much for your support and contribution in our event. And indeed, fighting with counterfeit products, both in your side and in our side, is the priority. And now let's turn to the panel discussion. The number of people there, despite the fact that the number of people in the hall is not growing, but we see that there are more participants in Zoom. The good thing of this is that it's pretty easier to join Zoom conference online rather than attending it in person, and the panel discussion is dedicated to the protection of the trademarks, the current situation and the emerging trends is the first part. And now I would like to invite the first speaker, Dana Turgambayeva, State Revenues Department of Almaty City, with your talk, Customs Rights Protection on Trademarks in Kazakhstan. I'd like to welcome you, and I pass the floor to you. Good afternoon. I represent the Department of Custom Clearance of Almaty. I'm the Chief Specialist of the Customs Administration, where under the importation and exportation procedures, we reveal the products that represent intellectual property items, and we take the measures as per the customs code regulation. First and foremost, I'd like to tell you that we have the special principles. Okay, clear. So the custom clearance bodies take measures in line with the customs regulation purposes that are entered in the register of intellectual property. For the intellectual property items to be included in the list, it's done according to the Ministry of Finance, according to the Article 461 of the Code of the Republic of Kazakhstan on Custom Clearance Regulation. In order to include these items there should be the application, the information on the trademarks and the protection of these trademarks, the names and the codes of such. So the registers are upheld by the authorized body for us to reveal the violations. We also have the profile risk alerts for the products that are included in the list. So according to our Article 198, we suspend everything except for transit. The products that can be used by the consulate and diplomatic services, they are under exception, and they submit the information as per the simplified declaration. That's why we use it for both importation and export. We suspect and suspend under the Article 198. The order on the suspension is given, and then day in day we inform the declarant, the applicant, that imports a product. So there can be a suspension of 10 days, notification day in day, and we receive the information from the owner of the trademark as per the power of attorney. Sometimes they request information from invoices or the pictures, and if you have all those details, we provide them. But because we have the electronic declaration, the applicants should attach the invoices and other accompanying documents. If something is missing, then we request this information from the applicants. So the notification should also contain the information of all of the applicant. It's procured from the register, and the information is there. The representative of the trademark should have the only information about the applicant. If the information is available, everything proceeds from the declaration, article 14, and the naming of the brokers of such applicant. Besides that, we also have item 6 in our code where the trademarks are suspended for 6 days, and they have the rights to issue the trademark before the expiration of the 10 days period, or seek for the rights, administrative or civic rights. Such actions are there. Okay, if the right owner gives the permission, then the order is made upon the permission letter and is issued on the day of the declaration. If the right owner does not provide the app as per the power of attorney within 10 days, and no measures are taken within 10 days, so the law is released on the 11th day. Sometimes it happens that there can be the seize of the product or arrest, and the good will be there in the warehouse until any decision on that is taken. Besides that, the representatives can recurse in the administrative mode to the court for the protection of the trademark. These are the terms when the arrests are imposed, or when a person recurses to the court for the right, and the declaration is not issued until a decision is taken for the product. So the suspension, the halt is done with the orders, and we notify and the representatives that act on the power of attorney based on the 10 days period. On the 11th working day, he may request for the inspection of the product, asking for the picture and all information of the product that is located in the temporary warehouse. And if a person goes to the court, the declaration will be extended for 10 working days. If a person seeks for justice to the department, and if necessary, it is extended until the ruling is made. This register of intellectual property rights items is held by the Committee of Tax Revenues. You can see them in the committee in the activity section with the customs control, and there are many registers, including the register of intellectual property items. It is being renewed every week. Sometimes the terms are expired, and the trademarks can be extended. So the term of the trademark is incorporated here for 2 months, and if necessary, they are extended as per the application. So the department for 8 months of statistics, we suspended the trademarks in around 310 declarations have been submitted, both for import and export. 896 items of different products, and the representatives of NIIS Kazakhstan, of Apple, came to us to punish the satellite line company according to the Article 158, because they delivered counterfeit adapters, and the same goes to Bosch company. That was a huge amount, and that's why we had to submit this dispute to another place, and they won the court. There was an amount of 8 million. Actually, the way we hold the round tables, this is what was done in GTSU. We invited the representatives to act the ones who represent the interest under the power of attorney, the interests of the trademarks. We organize the seminars, we do the capacity building, how to reveal the fake products, how to find them, how to detect them and investigate, especially for the trademarks that are in the temporary warehouse. They undergo custom clearance and they inspect certain products, and then based on that we hold the roundtables and give explanation to our employees for the items that are in the list of intellectual property items. So if you have questions, please. So my name is Ainura Rezbekova. I'm the trustee of LLP Alina Group. I have the question of the inclusion in the trade register. On the day of writing the application and its submission through NEOTESH, the code provides for the submission of the images and pictures of fake products. The products that violates the exclusive copyrights, and what happens that there is no fake products for a particular product, and we want to be included in the register for preventive measures for parallel importation or exportation, because I remember in 2018 it did not require to provide the packages of fake products, but also to provide the signs of distinctive products. So will we be able to be included in the trade register if we don't have fake products yet? I may answer this question. Yes, this requirement indeed existed, but today it was not lifted. So that's why it's enough to provide the description of the original product, a detailed description to bring the trademark in the register. Yeah, I would like to apologize. We are extremely limited in time and there is no time for our discussion. We will take your question during the Q&A session, and we will have a separate round for your questions. Dana, thank you very much for your talk. Dana is the chief expert of the tax authority in terms of regulation. She regulates all the custom matters. She regularly attends the court hearing as well as the seminars of custom clearance experts. And thank you very much for finding the time to share your experience with us. Thank you very much. And now I would like to hand it over to Timur Bekmen of the Union of Patent Trustees of Kazakhstan, and his talk is the protection of trust importation in Kazakhstan. Timur is an advisor of Grant International and manages the intellectual property rights activities. Timur, please, the floor is yours. Could you please start my presentation? Legalization of parallel import in the neighboring country, in the Russian Federation, increase the stream of products. This stream goes either directly or in transit from Kazakhstan to third parties to Eurasian Economic Community countries. So the standard scheme of the product import in Kazakhstan or in the Eurasian Economic Union countries can be seen on the scheme that the producer or the user of the trademark supplies the products to licensor or according to the agreement, and then the distributor in the country sells this product to the shops. So how the system with parallel import works The shops and stores don't buy through the authorized importer, but from the third countries who buy this from other manufacturers. The parallel importation is forbidden in Kazakhstan. If you speak in a simple language, the import of regional products on the territory of Kazakhstan or Eurasian Economic Union countries or authorized body without the right holders in notification. What are the protection procedures? First is the parallel prejudicial settlement. So the right owner has the right to submit the right title or the trademark in the register. There is also the administrative procedure and civic protection. Well, when it comes to prejudicial work, the letter can be sent to the infringer that demands that the importer must not submit the products and sell the products in the country. If the product is placed on the informational platforms, I mean in the marketplaces, in the informational mediators, one can fight with the counterfeit products. And if the person finds the violation, a person can go to marketplaces, the informational mediators that will provide the platform for the sellers to sell their products. Recently, there are many ads on the marketplaces for parallel importation. For example, the well-known Kaspi, if they find the trademark or the rights on the particular item, the seller can be restricted from the shop and from the store, and cooperation will only be continued if the guarantees will be provided that there won't be any further violations. But if there is a second violation, then 90 days will require, and Kaspi may forbid the user for indefinite term. The same goes to OLX. If the right holder finds the violation, he may block the seller. And the same case for Wildberries. If the violations are found, they can block the seller on the site. So on Wildberries, furthermore, on behalf of the seller, sell the product. With respect to the mechanisms of boundary protection, here you can see the way the rights for the trademark are protected. So the product enters the territory of Kazakhstan. The customs prevents further dissemination of the product for 10 days, and the right holder has the right to suspend the clearance for 10 days, and the right owners also have rights to go to the authorized bodies or to recourse to the legal civic court. If the answer is not provided, then the product goes on the territory of Kazakhstan. On behalf of the right owners, so we prepare the letters of authorization if there are no claims. What authorized bodies and agencies can be in charge of the intellectual property rights? The bodies of state revenues, tax committees, and in case if the criminal code is enacted, then the Ministry of Justice and anti-monopoly body. So the civil responsibility. When it comes to civil responsibility here, these are the requirements that we set. What it comes to a parallel importation, the infringement or forbid of further dissemination of the product, recovery of the costs of the right holders, compensation of losses. In practice, it's not impossible to recover costs and losses because one have to know the volume of the sold products, and the courts not always meet the halfway. They normally request the documents that confirm the sales of such products. There used to be several cases when the courts referred to the fact that this is the cash book or something else that proves the information, and the rejection and the seize of the products from the turnover in the revenue of the government. So in addition to the fine, there can be the confiscation of the products, and this requirement is submitted to the court. When it comes to the destruction of the product, sometimes it can be the story about the medical devices. According to the Code of the Republic of Kazakhstan on health of the population, if the products on medical drugs are imported to Kazakhstan, they must be seized or destroyed. There can be the lack of the existing registration certificate if the products are imported without certificates, or the term of the date before the best before date is expired, as well as there can be other requirements related to the destruction of the product. So in here, when it comes to the signs of violations for parallel imports, so the position of the state body and the court is simple. If you wanna deliver the product to the Eurasian Economic Union freely, you have to have the rights to use it on the territory. If there is no rights of the right holders, and if the license agreement is not there, then the courts will act accordingly. So there is a practice like that already. In Kazakhstan, there are also popular marketplaces like Kaspi, Olix, Ozon, Satu, etc., where there can be the placement of the products of parallel importation with which the right holders are fighting. Now again, just a few words about the procedure itself of providing the proofs by the notary office. We involve the notary offices to check the internet pages with the sales and the offers to the sales of the products. Sometimes the records of buying products with the violations helped us a lot. Yeah, you can see the page with the advertisement of the product. It can be recorded, and then you can also record the purchasing process. That is a very useful mechanism that the right holders are using. Moreover, they can make investigations and interrogate the witnesses and others. So here you can see the judicial practice for administrative case of trademark mango. Here we used the services of the notary to record the facts. We bought the product for controlled purchase. We bought from them 2 or 3 times and they didn't provide documents. We went to the notary and the notary recorded the purchase of this product, then interrogated the witnesses, and we provided all these proofs to the state bodies, to the Department of Justice, and the Department of Justice submitted all these documents to the court, and we brought them to responsibility. So the case was that they signed the franchising agreement for the use of the trademarks, and then they terminated the franchising agreement because the products were bought not from the right owner but from the franchisor of this contract, but they were delivered in other channels. So this agreement was terminated, and despite that they kept on using the trademark, and they submitted a dispute to the court, and they punished the once who was guilty. For General Electric, there was a parallel import. The product was imported to the territory of Kazakhstan, and this product was halted, and we went to the court and we brought the violator to the responsibility. And again, here I'd like to talk about the regulatory document of the Supreme Court of Kazakhstan. So the marketplaces are not fixed in the legislation of the Republic of Kazakhstan, but there is a regulatory work that the defendant on the rights of authorship or associated rights can be the person who violated the property or non-property rights of its successors. For example, the publishing house that prints the documents in the contract with the right owners is not considered as the defendant if there is a client of the publishing house. So this statement can be applied to the trademarks and marketplaces are only the platform that publish the advertisement. There is a strategy, there is a practice that only the sellers of the products are brought to the practice, and I don't think that I have enough time for further talk. I think we can discuss the marketplaces outside the audience. If you have questions, please ask. So I have a request. Could you please put your questions in Telegram, and all of them will be answered. Thank you very much, Timur. Thank you very much for sharing this experience with us. That's a great pleasure for us to see you. Okay, and now I'd like to hand it over to Oleg Kuzmin with the report systems of digital marking and labeling, as well as the product tracing. He has more than 20 years of experience in IT, telecom, as well as in other positions as operational director, and in other positions he's developing business not only in Russia but also in other countries. And since the first day of CRP Turon, Oleg has been engaged in the development. Thank you very much for this opportunity to come. Well, thank you very much, colleagues. Yeah, I'm the operational director of CRPT Turan. We are the operator of the digital system in Pakistan. Just a few words about what we have done and the current state of the digital labeling tracking in Kazakhstan. And at the end, I'd like to show you a few numbers that will demonstrate the efficiency of labeling. Okay, next slide, please. Okay, it is it. Thank you. Well, as a matter of fact, the digital labeling as an area is new for Uzbekistan. It has not been there for like 3 years already there. Since the first day of the labeling in Uzbekistan, there have been certain prerequisites. As strange it may seem, that there was a course to the digitalization of the economy. There have been serious improvements, and the development of IT sphere and the digitalization of all the spheres of the civic society was considered as the key priority in the country, because there are several requests, and the digital marking and labeling has embedded in the development of the economy. Another interesting thing that in 2019, according to the Minister of Economic Development of Uzbekistan, 52.11% of the economy was in shadow. The government did not collect more than the half of the taxes. This is the official information, and if you see the non-official information, then the government has no clue and has no understanding of the situation in the manufacturing of alcohol products, and didn't understand the volume of alcoholic products because the accounting system was not there. For example, the accounting of the alcohol was done in Telegram channel by the manufacturing plant, like I manufactured this number of bottles, and the excess tax was calculated accordingly. And then the participants of the turnover, the actuaries, did not understand how much they sold, and the country was engulfed by the counterfeited products, and they did not know what to do. And there was a huge demand from the country because the government opened doors and economic reforms started, and the strategic approach was the attraction of investments by foreign companies for them to access it. But no companies will go to the market unless it understands the sales of its products, and the sales volume was not clear, because one of the pharma brand told me that according to the official state statistics in Uzbekistan, they sold medical products as twice as more than they manufacture. So what's the further point of doing business in here? So this was something to be done about, and the marking and the labeling was designed to deal with these gaps in the economy on the one hand, and on the other hand, we needed a mechanism that the tax authority could be guided by the digital mechanism that ruled out different interpretations that would be that would be logical, and there were not accounting systems and accounting software programs, because the accounting was done in a paper form, and then the marking followed the development of all those areas. So that's why I always call on all colleagues during such events to consider this labeling not as something that is only designed to combat counterfeit products, but I will show you how it works, how the labeling works, and where we are now. The labeling, like I told you, launched in the beginning of 2021 in the industrial scale. We decided to use this labeling of the products. Then the medical devices, I mean the pharmaceuticals of the first and second group of drugs, of the first and second products. In 2022 we launched the third group of pharma, the insulin products. We also had the idea of labeling the pharmaceuticals that started to be labeled in 2022. So the Pepsi also marked the test batch. So only the labeled products entered the market. Only Bartholomew was there. So because the Bartholomew turned out to be the most faked product in the world, and the labeling demonstrated that the product is not faked. So in 2022 we started the labeling of the medical devices, both our local there is a tracing of legal products, except for the third group of medical devices. So these products and this legislation will be launched as of December 1. Here you can see that as the regulatory bodies in Kazakhstan, so the factors were the following. Before we launched the labeling in Uzbekistan, we launched a huge follow-up work around digitalization and labeling. The laws on digital signature was signed, and the electronic signature is given to the chief executive officer. The information is provided on the cashing machine, and the cashing machine should be connected to the tax authorities to submit data, and there are not so many people who try to do that, but the process is getting better. And the third point is that the legislation on the electronic invoice, all the documents, all the paperwork must only be done within the electronic signature. So our company was chosen as the labeling operator. We are working within the public-private partnership. We are the private partner, and the public partner is State Revenue Committee, and we believe that to be a good symbiosis. On the one hand, we work as an operator who is not the regulator and has no supervisory functions, and at the same time the inspection has access to our system and has the supervisory and controlling functions, and can engage in punishment measures if such violations are found. Well, we are actively working with the state authorities, with the ministries, with the committees, with the pharmaceutical industry, and a huge work has been done to improve the legislation as the labeling processes go on. Many things were brought to the legislation, to the state that are in line with the requirements of the modern world. As far as you know, the electronic signature in Uzbekistan can be obtained by non-residents of Uzbekistan, and that boosted the launch of pharmaceuticals, because many actors can be registered in this system, and many operators that do not operate in the market, they got the electronic signatures in other countries, including in Argentina. And before launching the labeling, the process was not going well from the Ministry of Foreign Affairs of Uzbekistan. But when the labeling processes come closer, all the embassies and authorities of Uzbekistan started issuing the electronic signature outside Uzbekistan. The electronic signature can be obtained not only for labeling but for other purposes. We are the actors of the market. We perform a giant work with the market stakeholders, and when we launched the pharma, if I'm not mistaken, there were more than 1,000 meetings with importers, with exporters, with distributors, with manufacturers, both local and foreign ones, and the Association of Pharmaceutical Importers, so with the colleagues from pharmaceutical agencies, etc. And the final document on labeling, based on all those inputs from the market actors and the business actors, was different from the original version that we wanted to launch. And there is another subtle thing, colleagues. No matter how it sounds, but the business must be heard, and the government should not forget about its own purposes. I mean, the creation of the fair and equal rights in competition and tax collection, because some of the manufacturers can be heard so much that new measures are required. So the approach that we use in Uzbekistan is different from the approach that is used in Russia. For example, we have the equal and similar legal framework. We are working as per the requirements of the Cabinet of Ministers, with clear objectives of the labeling and other provisions of the labeling procedure. That provisions, they don't contradict each other on the one hand, and on the other hand there is the connection of the legal framework stakeholders, and they can see where these documents are. So the equal system of labeling, we built our labeling as per all the processes in line with the IT labeling system. As far as you know, for example, in Russia there is one system for milk, one system for alcohol labeling, and others, but we have one core for all. The system is being improved, of course, for the specifics of the product group, but the great improvement was too far aimed at pharma. The core of the system was improved. They could have done it faster, and that allows to scale system considerably and launch new product group from scratch. So the analytics for state, because you know the tax authority is our partner, and the tax authority has access to that. They had Excel reporting system, but over these 3 years we have done a great leap in business analytics, and we managed to create the risk management for the committee, and that's only the first step in this journey, because the appetite comes as you eat, and there are many requests from colleagues, and colleagues may track any extremes of different values for manufacturers, for wholesale, for retail, and based on that take measures, including the inspections and rates, and such work and such efforts are already there. The legislation has been improved for the reliability of the labeling. That implies a fine of half of the turnover of the company. The fines are pretty huge, and they allowed them to realize all that for half a year, and then specific court hearings initiated. When colleagues from the tax authorities see the database, and they observe that millions of bottles of vodka gathered there, then they tell them like, show me this 1 million bottle. Somewhere you declare that there is 1 million bottle, just tell me where they are, why you sold only 20. So based on this information, we keep on large scale training events we created from scratch on our basis. The tech support 24/7 call line who communicate with all the stakeholders. We have a Telegram chatbot, we have electronic email. Well, what else? We receive hundreds and hundreds of requests every day. So another important thing I'd like to draw your attention to, there were some words from the previous speakers about the marketplaces and the way how you can make people buy the products they really want to. So the labeling is exactly designed for this. That allows the buyer to understand what he's buying. This is not a fake product or not counterfeited something. With the use of our app, he can scan the code and he can see the whole information on this product, when it was manufactured, was it withdrawn from the circulation, should it be there, is it faked or not. If the data, if the label can be scanned, then this product may not be sold further on. So it's seen that the product cannot be in the circulation, so the buyer will decide, of course, not to buy it. So furthermore, our partner, the tax committee, has introduced the same feature in its own app. There is a Salikus in Uzbekistan. It has a huge variety of different features, and 1.5 years ago the features for submitting claims in the sales point of sales is provided. For example, the receipt was not issued, and a buyer can put in information that the tax authority that this buyer did not give me a receipt, and the tax committee verified it itself, and then it finds the sales point, and people can get the cashbacks on their card if they do the whistleblowing like that. So for example, any person buys something for 10 rubles, then they claim that the receipt was not provided to the tax authority, and he gets a cashback of 100 rubles, for example. So these are the improvements. It is very efficient, and the tax authorities have a broader range of influence. Okay, just a few numbers in this slide, the last one. I'd like to tell you that the labeling process is a new one. It has not been there for 3 years. So the growth of the excess tax collection for alcoholic products was almost 30% as compared to 2020, and we expect the growth this year. But because I'm in charge of the operating countries, I'm in charge of the figures too. Sometimes we deviate with the state. If you can see the open source data, the growth of excess tax in 2023 is forecasted on the level of 40 as compared to 2023, but we forecast less. Based on the earlier statistic, the import of alcohol in Uzbekistan increased by 20%, but you need to understand that import of alcohol in Uzbekistan is traditionally low because we pay the excess tax. For example, the bottle of water abroad may cost not 20 but $30, because there is a lot of smuggling products, including beer from Kazakhstan. I know that Shymkent and Zhigulov beer were not imported officially, but there were many bars where Shymkent and Zhigulov beers were sold. Given the fact that the labeling destroyed smuggling of alcohol, the official statistics has come to life. As per strange it may seem, Uzbekistan is not an alcoholic country. The primary alcoholic products account for vodka, and the figures are growing because the consumption culture is changing on the one hand, and on the other hand that the smuggled products go away from the market, and people can enjoy better products. Well, another important thing in here that excess labeling on the wine products in paper was abolished. This is a new era of the labeling development. We are discussing actively with the state of digital excise tax on alcoholic products. That was a success story on wines, and the next logical step goes to abolish the excise tax for all the import products that are imported to Uzbekistan, and the final story of it is the abolishment of excise tax for all the products that manufactured in our countries and calculation of excise tax as per the matrix. There is a unique code for every bottle that allows to calculate the labeling. Somewhere it's more, somewhere it's less, around 17% of the whole time. But it depends. The importers of the domestic appliances is twice as high as we expected. Somewhere is a middle importer, somewhere someone is not. So I already told you about analytics and the last point when it comes to the creation of ecosystem. So there can be different stakeholders in the market. They could adjust the labeling system, and now there are more than 40 companies work in the market. Not only our companies, but also from Uzbekistan, from Russia, from Turkey, from Bulgaria, and others. They open up their local representation offices. There is an expertise in the country. So the actively being developed, the way the business adjusts itself to the development of IT and the requirements of the state. When pharma was introduced, then it could be marked either in the warehouse or in somewhere else. 1 or 1.5 years ago, I don't remember any custom warehouse where the products can be labeled, but now people can go and get licenses there. If a small batch is delivered, then they have a chance to get labels there. So now we can say that the labeling in Uzbekistan turned out to be successful as the area and the government sees the importance and the necessity of it, and the producer also sees the advantages, and the flow of violations of labeling rules and the number of our users in the mobile app are also growing. So that's a tangible tool in digitalization of the economy. Thank you very much for that. And now probably maybe I answer at least one question as long as we have time for it. Okay, so our reporters and presenters are very disciplined. Just one question, please. But I believe that once all people finish their presentations, we will have a bigger room for a Q&A session. Of course, the labeling is not the intellectual property right, it's area itself, but fighting with counterfeit products and illegal turnover of fake products is never there. So the labeling issues have been there for many years. There were different ways like holograms, barcodes, and other ways, and people expected that they will replace the trademarks within the program of the consumer rights protection, but it did not take place. And now let's move on to the practical questions from the trademark owners and the experience in this field. And now I'd like to hand it over to Anastasia Kuznetsova. She's the chief legal expert of Legal Group. The Legal Group, which has an experience working in Kazakhstan. Good afternoon, ladies and gentlemen. My name is Anastasia Kuznetsova. I'm managing the area of intellectual property rights protection in a legal group, including my competences include intellectual property rights in the Republic of Kazakhstan, where over the past few years, thanks to the collaboration with the authorities, with the Department of Justice and Customs, we have done a breakthrough. Well, thank you very much. So, my today's talk will be dedicated to the intellectual rights protection of legal in Kazakhstan. I will tell you a few words of what we are doing here in Kazakhstan and what kind of challenges we have. So, according to the statistics gathered by our company, the volume of importation of plastic constructors in Kazakhstan 2022-2023 accounted for 23 million USD. However, the volume of importation of original products is 6.2 million USD. So, if you know the market of legal counterfeited products, we have the grounds to say that the volume of importation of constructors that violate the intellectual property rights of legal exceeds the volumes of original legal. Most of the constructors that are manufactured in China in this or that way contain the violation of specific intellectual property rights of our brand. In this slide, you can see the pictures of some point of sales where the imitations of legal are sold, and I will tell you the problems that we face in the faked products. We have not like one-to-one fakes, but the imitations. From the legal perspective, it's challenging to fight with them. This is the legal imitations that are manufactured in Kazakhstan, where we are actively working. My key objective is to decrease the level of counterfeit products in the territories that I manage, including in Kazakhstan. We see that the violation is there, but in order to defend ourselves, we need to use as least efforts as possible to get as maximum results as possible, because our resources are limited, our capabilities are limited. That's why we are using the grounds and of our rights, because our trademarks are in the funnel of our rights, and if you can't go down in the funnel the specific violation of the trademark, then we go to exclusive author rights. We employ this fact, and if the exclusive authorship rights are not violated, then we go to the industrial samples. So this is the approach that we use in Kazakhstan, and this is the approach that we use in Kazakhstan because the volume is pretty big and it may seem simple with the trademarks, because we have the patent to prove our copyrights, and in order to ensure the efficient mass taken out of the products from the market, we must create the portfolio of nominations in Kazakhstan based on these trademarks. We consider them as the most efficient, and the brand itself, the legal brand itself, and the name of the product line. If there are some legal lovers, the ones who like our products, you can see that the lines and the names of the lines that are permanently manufactured are registered here, and this is not an exhaustible list of the trademarks in Kazakhstan. So the reason why we don't register the name of all brands in Kazakhstan, because we are the global company. We have to register every trademark in a specific country, but we understand that the specific term of life of a line is 1.5 years, and sometimes we don't have possibilities and opportunities for that to register a product. But even if counterfeit products appear, then we will turn the blind eye to them, and we ignore the faking of the lines that are longer in the period of time. And some examples of counterfeit products that were found on the territory of Kazakhstan. Now let's take one by one. So in the upper line, the examples of the original legal products, and in red is the counterfeit product. You can see that in counterfeit products there is no legal logotype, and this is the product that fully copies the design of our package that was developed by the designer group of our company, and use the trademarks that imitates the name of our product Chima in the top. Chima is not registered in the territory of Kazakhstan, and for example, if you have to find grounds to protect our copyrights, then in the funnel that you saw in the previous slide, we would use the author rights for this regard. The author rights that are copied one in one, except for the name that belongs to our company. Well, and this second example, that is much more cheaper when the box is 100% copy, and the rights for the copyrights protection, we use Ninjaga, Ninja product line. You can see that some unfair manufacturers use Ninja but not Ninjago, and there is a mixture. So in the application and in the claim that we would submit to the Ministry of Justice, and if we submitted the civil dispute, the civil claim, then we would give the product name. And another example is counterfeit products, and we would be driven by the Ninjago product line. Again, these are the examples of fake products that we face. In the upper part is the original, and in the bottom part is the counterfeit product. France is the registered brand name. The packs are copied, and in Kazakhstan we would never tell anything about the copyrights that are violated by the reproduction of our packaging brands, because it's more difficult to protect the copyrights. And in order to minimize the costs, including the intellectual and finance, we would be defending our friend's name. You see that the Chinese manufacturers in the upper right side, they use this red, yellow something logotype, and the examples of Bella products were given. They are not well seen, but in some jurisdictions, so we managed to create a practice within which the found violations of the exclusive rights for a legal logotype. This Bella logotype consists of hieroglyphs and Bella in the bottom. We didn't try that in Kazakhstan because we believe that the friends are enough for that, because they are identical. So the similarity between this Bella logotype and logo logotype are similar, but some jurisdictions acknowledge them, recognize them, and some not. Here we would like to mention the following thing, that in all these examples we founded our requirements with the fact that the trademark legal is violated. The legal trademark is distorted. For example, the Star Wars line was created in collaboration, and Star Wars is not the copyright that belongs to Lego, and we don't have an exclusive license for it. And the package was not copied one to one, but there are some manufacturers that put not Lego but Lee go, that is pretty different or even low. The manufacturers that do these fakes are pretty numerous, and you have to fight with them on the territory of the manufacturer country with that works with a certain success, and on the territory of Kazakhstan too, because geographical location of Kazakhstan is that there are huge quantities of counterfeit products on our territory. And now I'd like to talk about the counterfeit fighting measures in Kazakhstan. I believe it to be the standard scheme that many right holders are using. The customs register of the copyright protection, unfortunately, in our case, they demonstrated very low efficiency because we still face the fact that the customs authorities of the Republic of Kazakhstan suspend either the parallel import or the import of original products under the condition that the trademark was found in the declaration, but counterfeited products have never been submitted so far. The second measure is the administrative raids that are performed together with the territorial bodies of the Ministry of Justice. We have been working in Kazakhstan since 2021, but administrative measures appeared only in 2023, and that's why we have been working very actively in this regard over this year, and these rates turned out to be efficient. And the second one is the claim processing work as well as civic claims. This work is pretty complicated. It should be designed in such a way that it's not enough just to submit a claim, but you have to call the offender and explain where he was right, where he was wrong, and it worked well, and sometimes it didn't work well, especially when our legal experts in Kazakhstan wrote claims, and then the violators went to our official distributors and claimed why it happens like that, and they saw our fruits of work in the intellectual property rights. With respect to the civic rights for the production, okay, does it work now? Okay, good. So the civil risks have not been tested yet. And the reason why we didn't test them is that we haven't found any large importer or retailer that would be selling the fake products in a great volume where you can provide for the proofs with the notary office. And if we find a retailer like this, if you find such an importer, then we will be litigating within the civil code. Okay, and now let's turn to the statistics. In 2023, as of today, 15 administrative raids under the support of the Department of Justice were held. We, as the right holders, we want to tell you that within the raids, when we seized more than 2,000 fake products, the cases were submitted to the court in a prompt way. The infringers were fined and the products were sent to destruction. I'm managing not only Kazakhstan but also other CIS countries, and I want to tell you that the term of review of the case in the legal court is very short, and the procedure as well is very efficient. And the same way, we as the right holders can mention the following thing, that the products were transferred to destruction, and we had a chance to be to be the right holders, and we managed to track the way how we can do that, and the process is pretty transparent. And when it comes to customs, so far except for halting the non-original products and parallel importation. Nothing has been done despite all our efforts. The fake products were not submitted, were not suspended. Sorry. What are the advantages of fighting fake products in Kazakhstan? First is about open and kind people. It's the first time I'm in Kazakhstan and I'm happy to be here. First, the second one is that there is efficient work of the Justice Department. I'm happy to cooperate, to collaborate with you. I'm happy that you are very open. You communicate easily, and I'm happy that you managed the fake product destruction, because our company's objective is not to put anyone in the court and sue someone, but to remove the fake products from the country for two reasons. First, we have kids products that are potentially not safety. And the second one is the violation of intellectual property rights. That's why we have to seize and destroy. We are happy that we can see it. We even saw two news reports on TV about destruction of Lego. And fourth is the efficient transfer of the case to the legal court without delays within 4 months. That's an outstanding result. From the first day of administrative raid until the day when the ruling is made, then several weeks only. Okay, and now the drawbacks of the system. From my humble opinion, in case of legal, so because we have these specific imitations and specific fakes, we see that sometimes the customs on purposely halt the products which have the logo that is identical with the one in the trade register, like 1-to-1. It seems like the customs do not find for other similarities, and we want the approach to be changed. We want the customs when they use the partial similarities, and in this case that would help me a lot. And besides that, we have a feeling that the customs authorities they do not require compulsory fulfillment of the product lines in the declaration. So what happens to the declarations when the trademark item line is not filled at all? It seems like those products pass the border pretty easily, and for us as the right holders, it would be really interesting for us to deal with the requirement about the compulsory fulfillment, compulsory filling in the trademark line. If those declarations are not filled in, they should have been considered as the risk declarations, the way we work in Russia. And another interesting thing, I don't know whether the situation is with other right holders, but we see the following situation. For example, when the product, for example, a cargo passed the custom clearance, it entered the territory. The products have been imported and delivered, and the fake products are moving along Kazakh territory. And we know, for example, that in a specific track there are fake products, and we don't have any legal grounds to bring them to responsibility, to bring those to responsibility who transfer the fake products. That's why we would like to raise this issue, and probably in future we can involve we can enforce the responsibility for the fake products. I on purposely read the legislation of the Republic of Kazakhstan, and I personally saw that there is a difference between a limitation and import. And the third thing, and I take a look from our perspective again, the lack of transparency, especially in functioning and risk funding in customs clearance. So we have to know what kind of details we can provide to the customs authorities, what kind of information we can provide, so that the fake products are detected better in the customs, because the importers bring products with trucks from China through special security posts, and there are huge amounts, and we are working and responding to raids. When we work with the administrative raids, despite the fact that we are working with the large points, sometimes we can seize 300 to 500 products, and this is what we can do within the customs mode. And for us, for the right holders, we would really love to know what the risk detection system looks like and how it works, and for us to know how to better manage it. And if we do so, then we will be in a win-win position, both with us as the right holders and custom clearance as the supervisory authorities. Thank you very much for inviting me here. That was the best practice of legals. Thank you very much, Anastasia, for your report. And the only thing I'd like to tell you is that you are fortunate that you are allowed to distract products, because unfortunately it is not always possible. That's why the level risk is always high, and this is not always in our capacity, in our power to allow for the destruction. Okay, thank you very much for this comment. I will know that this is the governmental authority, right? And in this respect, I would like to tell you that we were even twice happy, and after that the fake products go to the property side, and we don't know what happens next, because some products must to be destroyed and we have no chance to supervise it, and some products cannot be destroyed. For example, the for leggings or other textile products. Oh, okay. Unfortunately, the last speaker in this panel session did not join us, and I hope that he will be on air very soon. But because we have extra time for now, probably we will be able to discuss some questions now without waiting for the official timeline marks to start. Okay, maybe you have some questions to Anastasia, please. I will be really happy to answer them. Well, we have two volunteers. Okay. Yes, please, Anastasia. Thank you very much for your outstanding report. So I have a question. When you come to the Justice Department, do you provide a comparative analysis that the supervisory body like the National Institute does to prove that your rights have been violated? Or there is a similarity in the product. So before coming up there, you ask for the comparative analysis. Yeah, for a number of trademarks, we have the expert opinion. Okay. Please introduce yourself. Okay, if Stefanova Ekaterina, Syngenta company, could you tell me, please, what's the situation looks like with the investigation and criminal proceeding about criminal cases? Have you had criminal cases? No, we didn't have enough volumes for criminal cases, or what? You know, there should be a certain threshold to be respected for the damage, but unfortunately, this information has not been there. Well, sometimes if there is about if there's about 30 packs of Lego, they cannot be treated as the criminal responsibility. And when we talk about the industry, there can be the trade points and points of sales like stores or the markets. Well, I can go into details the way we find these points and the way we work. Like we know about the problems in the markets of Kazakhstan, but it's a little bit difficult to work with them because before you submit an application, a claim to the Ministry of Justice, you have to do the controlled purchase and purchase. The checks for the receipts for the purchase are not submitted frequently, and if you fail to do so, we work with the trade points. First, we search the keywords of in the internet. We search where the sales points are. We do the round with it, so we check if the sales point is small or big, and we ask if you can buy the wholesale products, and then based on this analysis we find the sales points that according to us, according to the results of our investigation activities, are considered as the biggest one, but we haven't had a very big one, giant ones. There was one rate in the market, more or less a big one, but this was not the criminal case. In which regions are you the most active? No, I mean the rates are most active. Well, for rates we have three large cities: Almaty, Shymkent, and Kostanay. Okay, next question. Anastasia, may I ask, Colonel, company, Mobile One distributor in Kazakhstan, you have a vast experience in fake products fighting. Have you had successful stories when you passed not the custom clearance, but through the territory of the Eurasian Economic Union countries of that for the products that come to your country? Do you have an experience in this regard? Unfortunately, we encountered this problem when the products were brought from Russia to Kazakhstan. A product from Russia comes to Kazakhstan. Does the single register helps you with this? What kind of successful stories in interaction and contraction do you have? We have the opposite situation. Well, we haven't had such issue with Kazakhstan, but we had some practices when, for some reason, a huge bulk of products go from Belarus. But here in the Russian Federation, there are many mobile customs group that can stop the trucks when they have already passed the border, and they are entitled to inspect them. And this mobile customs teams have caught many times large trucks from Belarus to Russia that was already on the territory of customs union, and the practice of seizure was in line with the legislation of the Russian Federation. We received messages and with a request to prove the fake products. Normally, it works in a different way. The customs submit a claim to the court, and we are attracted as as the victims, and we are involved in the court's hearings. So this is how it works. This is when we don't have an experience from Russia to Kazakhstan. We haven't caught like this. So probably you can work with Russian and Kazakh customs. So this is how it works. This is what we are doing. Okay, thank you very much. One more question, Anastasia. When you bring people to the to the legal or civic to the criminal responsibility, do you involve contractors? So I will tell you the following thing. There are no labelings or stickers on the fake products. They are nacked. there can be an information of the manufacturer on the territory of China, and normally there is no marking like this. There is no idea of who the importer is, and we have no other choice but to bring this businessman to criminal and or administrative responsibility. If the requirements were stronger for labeling of the products, for bringing the information on importer, then we would go to the importer if we knew about him, but we have no clue who he is. But in our practice, we face the problem when the state authorities brought decided not to bring the seller to the responsibility, because the seller has no responsibility because he didn't manufacture it, and then they send a claim to the Eurasian Economic Union to bring the producer to the responsibility. But executive authority did not allow us. They rejected our claim to bring the sellers or dealers to responsibility. I don't know how to comment it. Probably this decision can be challenged. Okay, thank you. Can you hear me now? Ira Rahmetovna, for Kazakhstan, I have a question to the justice representatives. It seems that she left our conference. Okay, but could you please share your experience from the first day when the request was sent to the Department of Justice until the day the ruling is made? How long does it take? I will take some time to answer you, but it depends on the situation. Sometimes 1 week. What kind of measures? For example, there are some receipts with no name of the product, or do you accept the video recordings? And very frequently, the businessmen are working through bank transfer through Caspian and Halek. To what extent the justice is ready to accept these receipts on money transfer? In electronic form. I think that we can go to the Ministry of Justice. We tried with Kaspi checks, we tried to use the video recordings, and we wanted to use the whole combination of proofs. But if the receipt has no item, that's a standard situation. Normally, we record videos and we send this check. For example, when there is one thing, even one tenge or something, these receipts are accepted. And the receipts are very important, especially when it has to do with fake of products, and in the small sales points. In the same way, they don't have many products, and from the first day of request, they have enough time to sell all these products, and the product is not available in the sales point, and you never know when the next batch will be delivered. And given the fact that we have the food products and we have many fakes of the food products, especially the ones who are designed for children, I think we can talk to the Ministry of Justice. Yeah, I would really happy to know the answer to those questions from competent authorities. Yeah, we also had an issue when we saw the faked legal products in the sales point, and we made the test purchase, and we managed to evaluate the volumes, and we were waiting until the measures are taken, and by the day the measures and the rates were performed, the products have already been sold. Thank you very much, Anastasia. Probably there would be other questions, but I think that the first they will be recorded and then passed to you, and I hope that we will have a chance to answer these questions. Okay, there were questions to Dania. Unfortunately, we decided to bring them out of this hole, or to ask them offline. So I would like you to again come to the mic and answer it. Thank you very much. Good afternoon. I have two questions. First, we encounter it in practice. So the first question is when the executor who has this claim on hands, they ask the images and photos of fake products, and I answer like the fake product photos are not required. And the executor tells me that it happens if I request something, then it is required, but we have to take it. You know, they have been created a single window where you can pass the claim, but it doesn't work that well as we expected. I talked to Gulia, she the expert, and she told that the photos are not required if you don't have them. The photos of fake products, but the executor requested that, but because of that we will be rejected. So the committee itself requires that, and they told me that such images are not required if you don't have that. And the second question of including the products in the customs register, for example, we have Alinex or yes, they are in the register, but what I mean, for example, for Alinex brand more than 50 products are manufactured, and when you include Alinex brand in the list, they ask us the original packaging comparison. So, for example, we have 50 different products in our product line. So, should we prepare for 50 products? But can we use, for example, one putty is an Elinex brand can be halted, or there can be different marking of the labelings. But the question is, when the brand, big brand comes into play, they have to provide the distinctive features of original packing, and the question is in here to include the full line of Alinex brand, and other brands can be excluded from the packing, and some distinctive features can be given. So what is to be done in this respect? Well, let me discuss that with the committee, and I will give you an extra follow-up on that. Okay, Anastasia, please. Well, Dana, have you seen it in my presentation? There were some questions, and the first question is, if I understood you correctly, it's better to include the verbal trademarks in the register, but not the labelings in original font. I cannot explain what is good and what is right. So it is given in the program. So because we don't know this task ourselves, this is the risk management system that responds to that. There used to be the combination of, for example, HP. If there are two letters H and P, this program, this software responded. I don't know how it works now, this software, this program, but in 227 they must fulfill that. And we check it because the electronic declaration system is a new one. It is of 2018, and there are certain drawbacks. Yes, I understand, but I just wanted to ask you about the risks management system, because the fact that you mentioned that what we as the right holder, what kind of information we need to provide, we need to know that you'd better talk to the committee, because the system also involves the authorized body, and we have a special article of the unfair applicants. You need to put them from different sides. So these marks or whatever the information is must be filled in. There is also T and VAD code. There is also a classificator of the intellectual property rights, and if the trademark is registered, then the applicant will know about it. So we hold the roundtables, we explained how it works, etc. Both for the broker company and T and VAD. I mean the foreign trade codes, and if the product is registered there will be 010 classification, and if the product is not available then IS 100 is given. But if the trademark is there but it is not registered, there will be I 20. Okay, thank you very much. Thank you very much. We hope for further improvement. Okay, thank you very much for that. Yeah, indeed, some of the answers require our additional work and our additional time to think. Okay, please double your questions in Telegram that you asked, just for them to be more comprehensible. So do you have any other questions to the representative of the Ministry of State Revenues? Do you have any? If not, then okay. Thank you very much again for coming to our rostrum. Okay, if someone else has questions to Timur Brekmayinov or to someone else, please ask your questions. Raise your hands, and we have time for that. And I would also like to thank the YP company organization for that. And probably, if you like, we can have another cup of coffee. Do you have any questions to the trustees or questions related to the labeling? Well, they are not linked to our day-to-day work, but it's extremely important in Kazakhstan. In Kazakhstan, after Russia, some of the issues are being resolved in an interesting way. So I have a question to Graf. So just tell me, please, if, as far as I understand, in Kazakhstan, you can request to delete the parallelly imported products. You can delete it and then prove that it is imported in parallel. Well, I think that you can make special purchase, controlled purchase, and check how the chain looks like, and then you can check whether the products were imported legally or illegally. You can do that. You can track the situation through marketplaces if you do the test purchase. Okay, and another question: if the product is declared and it is imported in parallel importation, so the right holder is informed about it, but if what happens if the right holder does not respond to the request of the customs? Normally what customs does, it says, for example, there was no notification if the product is legal or illegal, and then the right holder does not answer to the request of the customs. What happens to the product? Will it be released or not? If you don't answer the custom clearance, then the product will be released. So it turned out that there was a slide that bewildered me, and they cannot provide the parallel license as an importer. So any products, fake or non-fake products, they have the regulation of 10 plus 10 something if the letter is not provided or whatever. So, and if the right holder answers that this product is original but parallelly important, will this product be subject to the same responsibility measures as fake products or counterfeit products? Yeah. Everything according to the same scheme, but the destruction is not provided here, so they are seized to the revenue of the government. Okay, I have a question. So there are experienced legal experts that could share their opinion for the question asked. For example, the previous question had to do with the State Revenue Department. If you want to add something, please go ahead. But meanwhile, you have a question. If there anyone who wants to follow up, please raise your hands. Timur, good afternoon. My name is Ainura. If I understood you correctly, the marketplaces, they work as the publishing house. They will not be the defendant in the court. The same goes to marketplace where many fake products are, and if we ask to deactivate, to remove the seller from the store, we will not be able to bring Kaspi to responsibility. There is a regulatory document that also has to do with intellectual property documents. If you send a letter to Kaspi and if it didn't respond, then you can bring Kaspi as a co-defendant and claim that Kaspi did not respond to your claim. You can bring them to the responsibility. They are not brought to the responsibility only in case if they place content, but if they misuse the rights, they don't answer you, if they don't block the seller, you will be able to remove him as a co-defendant in the legal hearing if it turns out that they are not defendants. And meanwhile, Kaspi responds to us and thereby fulfills its commitments. And the producers of construction mixtures fulfills it, but for example, the sub-brands are sold under the trademark. Other brands are sold that belongs to Alina Group, and we face the fact in Kaspi that it does not request the proof of the intellectual property rights of the product, but also the names of the product range. He answers it answers like the product is registered, but Kaspi fulfilled our demands. So if something happens, this is for the future. Well, as long as we work with Kaspi, in many cases they fulfill their requests that are sent to the right upon request of the right holders. Here we can find other grounds for further work in the judicial proceedings. Okay, other questions, follow-ups? Okay, thank you very much. And now let's turn to our colleague who has a question. My name is Anand Baeva. So I would like to ask you the following question. So how does the labeling of the product in Uzbekistan take place, and how do you combat with fake products? We know that that's a big market of fake products. The kids books, course books, textbooks in Uzbekistan. Well, the labeling of books in Uzbekistan is not there, and we don't do that as the operators. Yeah, you are right. Unfortunately, not only the market of the published products is full of smuggling and smuggled and fake products, including the shoes market. We, as the operator, we receive many requests from the shoe manufacturing companies, and in 2 years they came to us 7 times asking for the labeling of the shoes. It turned out that the shoes are faked in China, brought here and sold 7 times cheaper. So the state is engaged in the labeling procedures, and we have to meet our commitments to the government until 2025, and then the labeling will be improved. But now I cannot comment on that about any rumors, just not to allow for further rumors and gossips. Well, if you find an information in the open source, then then fine. But now they are discussing to introduce marking and labeling in several areas. If I'm not mistaken, 7 of them, including industry and food ones. Okay, the simultaneous interpretation is there. That's why could you talk to the mic, please? So when it comes to the fake products, we know that the fake products come from the typography, from the publications. They manufacture something, and does any publishing house um, bring to the responsibility? Well, the colleagues mentioned about the brands asked for the criteria of mixtures. In the Ministry of Justice, there is a special group that is fighting with them. Once a quarter, they publish the catalog or in comparison of original and mixed and regional brand and fake brand mixed one. I think this fight is not as efficient as it should be, because the government has no chance to fight with them. You know, the marketplace were mentioned a few times, and now we have the biggest marketplace that is called Uzu. That's a fintech platform very similar to Kaspi and Tinkoff. In Uzu market, it's forbidden to sell the unlabeled domestic products. We have been working with them for 4 months in Uzu Academy. We trained all those involved in the trading. They were around 100% in every meeting, and they sold the balanced products, and now they are not allowed to sell any labeled or unlabeled products that are not certified. So if the labeling of the books, test books, will be there, then that's fine. That's a new move in the policy. Not all the questions are within the knowledge and experience of our speakers and legal experts, but I hope that the ones who are online now will be able to share their knowledge or their skills or expertise in this sphere. So please ask your questions in writing, and if you have any questions, or if answers will be provided later on, then we will publish them on our website. Are there any other questions, probably to the previous speakers? If not, then okay, you're all invited to the coffee break. You're all invited to take pictures against this beautiful screen, just to commemorate your presence here and to have something to remember. See you in 15-20 minutes. Dear ladies and gentlemen, dear participants, on that, my role as the moderator is completed, and now that's a great pleasure for me to hand it over to the next moderator, Rafael Garuti, Brasilia. Rafael, please, the floor is yours. Now you are the moderator.
Can you hear me?
Yes, we can.
Yes.
Everything's fine. Please continue. Now you're the chief.
Okay. Thank you so much for your patience, and I really appreciate the invitation. I would like to thank the office, Bolotov and Partners, and also INTA. Besides Attorney Law and partner at CNV Brazil, I'm member of Harmonization of Trademark Laws and Practice of INTA. So I would like to share my screen, and I will share the latest developments of class 9 with you guys. Okay, so let's start. First of all, I would like to briefly introduction about the class 9. The WIPO, the NIIS classification, divided the services and goods in 45 classifications, 1 to 45. And the class 9 is growing, and the growth in importance and activity of class 9 can be shown in the recent data we collected in INTA. As you can see, class 9 represents top 1 of the main countries classification. For example, US, Europe Union, United Kingdom, Canada. Class 9 is the class that most received trademark filings in 2021, followed by, for example, Emirates, Japan, China, France, and also Brazil. Class 9 is the top 10 classes in the world. So class 9 is growing because the technology is also advancing. In the recent terms, we can see that digital revolution, and we have a lot of information and technical equipments growing and developing. So class 9, is it a mega class to be? As the class 9 is constantly growing, the expansion concerning all the virtual goods in the metaverse and also NFTs, etc., we can think that class 9 could receive the items, the goods and services that are not protected by other classes. So what is the purpose of a classification? To divide, to separate goods and services and accommodate them in a single class. So the class 9 could be a class that in the future have more and more items that we cannot have enough space, enough terms to be included. And this is a concern in the not only for the IP offices, but also to the trademark practitioners, the IP lawyers, and also to the IP national offices. The classification in the NIIS classification, I mean, goods and services, they have their own categories. The national offices, they are looking for an efficient and logical way to conduct search and conduct the examination. So in the reviews every year, classification NIIS Committee of Experts, since its creation in 2012, every single year the NIIS classification has been reviewed, and the class 9 is a problem to solve. The class 9 is overload. And basically, we from Harmonization of Trademark Laws and Practice had the strong function and to study and to present some options to this possible solutions to this problem. Class 9 being an overloaded class, how can we solve this? How can we resolve this problem that day by day we can be expected to receive more and more items in the classification? Basically, we proposed 3 options. First one, dividing class 9. Option 2, transferring goods to different classes, not commonly used. So as class 9 is being used a lot, we can think that there are some classes that are not used too much. And option 3, adding new classes to the NIIS classification. And to briefly summarize and to put everything in a nutshell, the option 1, dividing class 9 in separate groups, is which us of Harmonization Committee of INTA think that is the most suitable option. We do have hierarchy terms created by European IP Office and WIPO that can be searched in the WIPO database. And this hierarchy could be a guide to follow. We can think that, of course, there are several possibilities, but we can think in creating class 91, 92, or 93, or combination in number and letters, for example, 9A, 9B, 9C. This taxonomy and hierarchy is being used by other IP offices, like China, for example. And there are another proposal made by USPTO in a project of the Committee of Experts in the attachment 5, that we can see how this class 9 could be divided. The headline, the first new class, and the second new class. It can be a solution for this problem. And of course, there are pros and cons. The pros is that other offices, as I mentioned, uses this already. For example, IP Office of China. And it's a more efficient tool for searching for the marks that can be connected and can be focused on this. And we can think that this divided class can be an option to maintain the same current system in terms of renewals, fees, and maintenance portfolios of trademarks. And this maintain, it will be keeping unchanged the current file and registered trademarks already classified as class 9. And it integrates with existing structures and divisions that could continue to be treated as class 9. And the cons, in terms of practice, it will be hard to choose the most appropriate subdivision for each good, not only for the practitioners, but also to the brand owners and also to the IP offices. And we can think that the currently filed trademarks, okay, they will be divided, but the existing registration, will be they also divided? And also the cons, we can think that adaptation of several trademarks databases, several computer systems, not only for the national IP offices, but also to the private databases. The option 2 is transferring goods. As I mentioned, the transferring goods is a good combination because there are some classes, as written by Robert from Clarivate, for example, class 13 for the guns and class 15 for musical instruments, 22 hoops and fibers, and 23 that yarns and threads. Those classes receive less applications. So maybe some goods from class 9 could be transferred. And this option has been appointed as a good option by the Committee of Experts in an 29th Committee of Experts convention. Majority decided not to change anything, but the ones that voted to start thinking in changing the subject of class 9, they consider to transfer entries, transfer items from class 9 to other classes. And the USPTO, for example, has already proposed transfer, for example, glasses, eyewear, in class 9 to class 10, for example, okay? So there are some options that can be thinking in this regard, but the pros and cons are, when we transfer the goods entries to different existing class, it would preserve the number of classes, 1, 2, 4, 5. So no adding classes and no extra fees will be incurred on changing systems and filing more applications to cover all the classes existent in the future. And the cons will be the number of classes that will be restricted. And new applicants will need to verify 2 classes. Brand owners will no longer have the possibility of having a registration in one single class. But in the past, we have something that we faced concerning classes, for example, 42, that was changed. For example, restaurant services was changed to 43. Some items from class 38 in the past was transferred. The classes 43, 44, and 45 in the past did not exist. And nowadays, okay, after 20 years, we are now used to them. But transferring goods is another option the committee of INTA bring to the floor. And the option 3 is adding or creating new classes. As I mentioned, in 2002, new 3 classes were created. After more than 20 years, we are now used to them. But this is the option that less receives support in the IP community, as I realize. It will be, for example, creating class 46, class 47, for example. The process that is a simple and effective solution. It will be avoiding the problem of monopolization of class 9. But the cons is it's been constantly more time consuming when we have a new class, because new classes means more fees and more time invested from the examiners in the examination. And there is also an uncertainty on the trademark searches and the classification. This is pointed out of the latest on class 9. In May, we had WIPO NIIS Committee of Experts meeting. I attended, and also the committee that I'm part of attended the meeting. INTA, our association, presented a paper related to class 9, explaining that is a mega class that is overloaded, and it receives support by the national IP offices, mainly USPTO and others, and it related to the International Bureau, they consider a new project in this subject. However, as the reorganizing class 9 was not in the agenda of this year, the working group only reviewed the proposed adding or changing relevant goods in class 9. So, for example, the proposal to add some gaming keyboards in class 9 were rejected and consequently added to class 28, but nothing more than that. And as a matter of conclusion, we need a solution for the overload class 9. There may be a MAG class, and is it expected to the national IP offices, IP practitioners, and brand owners? We need a solution. There are several impacts. Choosing one of the possible options we brought here, all then bring impacts, but the benefits should be considered. And of course, financial implications can be occurred, mainly concerning the brand owners that can receive more classes or divided classes, but mainly internally in the national IP offices. And there are some questions that we did not answer yet, but we bring to all the IP community. What are the costs involved concerning the national IP office to implement relevant solutions? How can we switch costs that can be mitigated by, for example, legacy registration? And are the IP offices well equipped to use two-digit or digit plus letter subdivisions of class 9? And will the change be financially accepted for the brand owners? So I thank you so much for your time. This is just an overview about the possibilities of class 9. And of course, I would be more than glad to reply the all questions I can from the community, and the hosters and can help me with that. But now I kindly invite Mr. Bolotov to have the floor and talk about the trademarks, language, and alphabets. So actually, you are the boss, so the floor is yours.
Рафаэль, я понимаю, что вы сейчас не можете сами себя поблагодарить за выступление, поэтому я, как бывший модератор, все равно считаю себя вправе сказать вам спасибо и интересный доклад. И вопросы, если они будут, все будут в письменном виде. Спасибо.
Okay, I thank you. I think so we can now pass to Tatiana. Is it okay? Or would like to have the floor because the translation, I didn't get it.
Rafael, я just say that as ex-moderator, I thank you for your presentation, because you yourself cannot thank yourself for such a beautiful presentation. And I said that any other questions, if any, you will receive in writing. That's all. Thank you.
Okay, thank you so much. Okay, then. So can we call Tatiana Gurbunova from the IP office to take the floor?
Rafael,
Oh,
she will be the next
talk.
speaker,
Okay.
and now
Okay.
the panel is mine.
Thank you so much.
Okay, thank you.
Okay. We have been already talking about specific aspects of the copyrights, and everything starts from the beginning. Well, it seems to me that from the beginning, this point is pretty fortunate. But in order to understand what to defend, we have to understand how we defend, because the trademarks are diverse one and the part of the intellectual property. When it comes to Kazakhstan, it has to do with other countries too. These are the non-material and property items that have the financial cost and financial content, but the most important principle is that the registration of the right does not allow the right to use, but the right to forbid the use of this intellectual property. In Kazakhstan, there is no concept like the right to forbid, but it demonstrates well the function. No one has the right to use the same or similar. If you talk about the trademarks, if it's not registered, then it's not protected. In separate cases, I know that the specialists are even the non-registered trademark can be protected, but a number of requirements have to be fulfilled. But in Kazakhstan, like in other countries in the US, the good example is not the one who started to use the rights, but the one who filed the application to use this right. This is not a brilliant example of the US. That's not the absolutely legal grounds, but in the US you have to prove your rights separately, and the registration provides with less efforts better tangible results. All the transactions must be registered. The same goes to the land purchasing. You buy land, you register it. You build house, you register it. So the licenses, the transfer of rights, everything must be registered. So there is a registration of all those changes, and those changes are reflected in the state register. But there are some contradictions with the bank secrecy. It may seem as a confidential information, but when it has to do with the trademarks or the patents, this information is available in the open sources. The protection territorially so the trademark, if the trademark is registered in another jurisdiction, not in Kazakhstan, it is not protected in Kazakhstan, and you have to enjoy of that, and you have to protect it. If your property is not protected, then you lose the value, and if other people unfairly use your product, then the trust to your product diminishes, and the value and the importance of your product goes down too. Well, in Kazakhstan, not so long ago, the idea of fake products was introduced. These are the products, either the products or its packaging. The term was not good, like the pack and its the product and its packaging must be there. If the products are placed without consent of the owner, they are considered as the fake products. There can be the product, the trademarks. The trademarks are different in Kazakhstan, like in other countries. These are the verbal combined pictures, numbers, and there are some sound trademarks. There is no idea of trademarks in Kazakhstan like in other countries, but this is the lack of specialists. There are not good. There are not good testers of different products to understand the similarity of products. For example, the smell of Lufthansa seats are registered as the trademark, but in Lufthansa, but not in Kazakhstan. The choice of trademark. When something is invested, if you have a firm that works, what's the point of having a firm? So the services and goods are provided, they can be used now or later on, and the countries that must have the protection. So another interesting thing is that the countries, and I would like to mention that in the beginning, that in some other countries the trademarks are perceived in a different way. It seems to me, for example, if there is no registration or just in time, in a right time or in a right country, then the violation appears. For example, the experience of Rahat in China, the trademark of Kazakh largest manufacturer of confectionaries. Once the first test products were imported to China, this trademark was registered by Chinese companies, and it took us 2 years for all procedures through legal hearing to deprive Chinese companies from this mark and register them for Rahat Joint Stock Company. Turan Lem, you remember there was a bank in Kazakhstan. When they opened branch in Georgia, they started to sell products to Turan Lem, and bank has nothing to do with that. And when the management went to their branch and they bought the cases with wines from Georgia, and if this brand was registered for wines in Georgia, all was well acknowledged. But Turan Alem was happy with this the additional popularity of their bank branch, and wine was pretty loved by the bank employees. So when the registration of the brands are registered in all countries, first you have to check the grounds, the absolute grounds, and then relative grounds. So the absolute grounds, the use of the state symbols in the trademarks, etc. Sometimes, in particularly, there can be some moral things and humanity. For example, in foreign countries, for Spanish-speaking countries, and Portuguese language too. Our Soviet cars were not popular. Zhiguli cars not popular because they provoke the association with the word Zhigalo, and that's why the name Zhiguli was mentioned. That's why in our countries and in other countries, in other countries, Lada. Pajero was good in our country because it was accepted and acknowledged in the English form of reading this word, because in Spanish J in the middle pronounces as ha, and these cars would not be popular in our country. In different languages, different trademarks. For example, sometimes it sounds because it spells not the way people wanted to, we designed it to sound. For example, we had the same thing in Japan. We wanted to explain the same to our Japanese clients, and they didn't want to register our trademarks in their country. For example, there is no L in Japanese, it's R, and in China R is replaced with L. And in some other languages, the signs and some morphemes and phonemes sound in a different way, and there is a threat that they mean something bad, or they will be sound in a different way. Some of these spells are different. For example, stolichnaya in the US could not work for the local market, and that's why this name in other countries would sound in a different way. For example, here you can see the page in your books on the table. This is how animals in different countries speak. The frogs speak in different countries because of the phonetic peculiarities of a language that can be different in different countries. They will sound in a different way. For example, a Russian frog says kvakva. In Kazakh, it speaks bak bak. It speaks in a different way, and it's different in different countries. By the way, kvakva says the Holland. Holland duck and not krakra. It means that Russian frog speaks with Holland duck and they can understand each other. So this is how it works. Without going into details with a trademark, I took the name of a person as an example. The name is spelled in different countries. This is the spelling of different names. Yura is one of the old Slavic names that is used in the modern language, and Yura is being used as a name. It means this sun like solid. The view of the sun has no other properties like shining or heating, but the same word in different languages is spelled and sounds in different way. The graphics, the word Yuri will be in different languages, spelled differently with their hieroglyphs, with the letters, and with the transmission of different sounds. For example, in the Cyrillics, with the use of Cyrillics, in different way of using, for example, E with a dot on top. That used to be in Russian language too. So the same brand in different languages will look in a different way. And now, with respect to the semantics, word Yuri and the name Yuri can be pronounced in different ways. For example, in one of the Belgium conference, I talked to the patent trustees and I asked them to spell their name and surnames in hieroglyphs to have a positive connotation with something good. This is very important for Chinese trademark in China. If the trademark does not mean anything in China, it means nothing. It has no trade function. it had different bins. They decided to use Yuri from one side and Bolotov from the other. Now, when I communicate with Chinese, I use the signature in Chinese, and sometimes we use the name of our Chinese spelling in a good way that allows to establish good relations with Chinese companies. This is the tribute to the respect, and the words were found purposefully. Yuri in Chinese means flower, and Yuri is a lady's name in China, and sometimes they put Madame Yuri in letters. Yuri means in Korean as a glass. In Japan, Yuri will never be registered for planting flowers, but for plastic products similar in flowers. And in Korea, Yuri will not be registered for the glass production. That's why you have to understand what your name means in other countries, what your brand name means in our country. Well, I will ask you to switch the slides. Next slide, please. So, creation of brands. They can be the transcription or translation. Semantic translation. Sometimes it happens in China when European brands or former USSR brands from China go from Europe go to China. Either the translation, semantic translation, or the transmission of the letters and sounds. These are the well-known brands. Here you can see the way they are spelled in China and the way they are pronounced. They pronounce in different way. They look differently. You will never know that it is Fanda if you don't know Chinese. But this is the prerequisite for accessing another market. These are the good translations. There used to be transcriptions. Here is the translation. They are not similar and at all, and they sound in a different way. So the trademarks of different names. When Coca-Cola entered the Chinese market, the direct sounding of Coca-Cola, it would have an association like a bite, the wax cells that had a good association, but it didn't help in selling products, and the huge amount of money to change like kele, like the mouthful of happiness, and try happiness to taste. That's really important for other countries. The meaning or the sounding of the products can be different, but the similarities are there. In other countries, your brand good in Kazakhstan or in any other country would probably sound in a different way, in other sense, in other in other territory where other languages are adapted. For example, there can be some countries where the brands can be adapted for two languages that are spread in the country. This is what we have to do, especially when we are instructed to register the trademark somewhere abroad. Oh, it doesn't work for some reason. Okay. Selection of the trademarks. So the alphabet, Kazakh, Russian, and Latin. Kazakh alphabet is being transformed from Cyrillics into Latin language. But nevertheless, there are some letters that are similar to Cyrillics. That's why not all the letters, even though the Latin alphabet will be used, will not be understood by English-speaking countries because of the inconsistency of different letters. If these are hieroglyphs or letters, what kind of letters or hieroglyphs to be used to register the trademark? For example, we want to use the Madrid system of registration, filing of the application to IPO. We want to register it in other countries based on the request in Kazakhstan. If you want to spread it in Asia, Malaysia, Indonesia, where we use the Chinese or hieroglyphs, so we need to submit this request in hieroglyphs, but hieroglyphs here will not be distinctable. The request will be accepted by the registration will be denied, because if you don't have this is like a central attack when the trademark must be defended. It can be used within the first 5 years, and if you are successful, then the request either will be rejected or will be cancelled in other countries. So unfortunately, this unsolved problem has to do not only with Kazakhstan but with other countries. It must be taken into consideration in other countries when the trademark is being invented. These are the examples that these are different alphabets. These are the cigarettes manufactured in Uzbekistan. When I saw these cigarettes, I wanted to know how it's pronounced, Xon or Hon, because the Ha in a new alphabet was adapted from Cyrillic's alphabet, and it pronounces like Ha, the same way Hon. So before you apply a request to file to get registered, you should talk to the legal experts. First you need to do the linguistic expertise first of the trademark, and then send a request to attorney. For example, BMW in Kazakhstan, will the derivatives be automatically protected of BMW in Kazakhstan, or transfer of the letters like Beha or Boomer? If a big Jeep, it's called Boomer, but if it is in red, then it's Beha. So these letters, these signs, despite they are similar, they will not be defended with the registration. Rahat trademark looks in a difficult sign form. It's difficult to pronounce it if you don't know what language it's written in. It can be Paksat if it is Latin, or it can be Rahat if it is Cyrillics, and such forms must be avoided, especially when the products are exported abroad. For example, or China or somewhere else. So this name will be registered, but we need to understand whether it's difficult or not. Another interesting question was for the customs protection. Should we register the combined verbal parts or verbal in general, and how to register it in Latin or Cyrillics? I believe that, maybe I'm not mistaken, but we need to register the verbal both in Latin and Cyrillic writings, because one of the famous tricks of conmans or illegal importation is declaring of the trademark in other alphabet or other language that it is written. Latin names are written in Cyrillics and Cyrillic names are written in Latin, and that's why these systems to detect the names Astana 1 or Astana 2, they don't catch these trademarks. For example, if they see that the product is fake, and custom authorities will see that the product is crosses the border illegally. So we need to understand how it works. So the program does not catch the combinated or graphical names. Undoubtedly, these are the verbal ones. The verbal names should always be given at least in dual languages. So I removed 2 slides, but I regretted about it. So if you use two different letters in one name. For example, unfortunately, I don't have the Coca-Cola bottles that were manufactured in India, Thailand, Chinese can as compared to our Coke. The Coke was written in a different way. That's why the design of the can with a red arc, a red and a white line demonstrated the recognition of the product for those who don't know Latin alphabet. When Anastasia demonstrated her presentation, where it was verbally said like some red, yellow, white sign in the upper right corner of the box. It's not known whether it's written something or not, because it's written in Chinese hieroglyphs, and probably it's recognizable, and probably it violates the rights of Lego Group in China, but it does not mean anything for us. We are guided not by the naming, not by the inscription, but by the analytical perception of colors and the forms of the sign. So that's an important part. Okay, in order to fight with fake products and counterfeited products, and to protect your rights in other countries and the rights of customs, you need to understand the semantics, graphics, phonetics, and practically, more likely, the way this sign looks and sounds, and the way it means in other countries will be different from the country of the origin. That's why you have to spend a lot of time, efforts, whatever, before this sign and trademark enters the market. And in order to have in order to be defended, this work must be done. Okay, what is to be done with the questions? This is up to Rafael, but I propose to take my footprints, I would say, of ex-moderator to wait until all speakers speak, and then we can answer the questions afterwards. Rafael, please, the floor is yours.
Thank you so much, Mr. Bolotov. Your presentation was brilliant. For us in the IP field, is really relevant and important to have access to those linguistic aspects of semantics when you were drafting a new trademark application, and also aiming the best strategy with the final consumer. So thank you so much for your brilliant words. Now I kindly invite Ms. Tatiana Gurbunova. She's from the IP office and she's attending in person. So Ms. Gurbunova, the floor is yours.
Вперед, назад. Или у вас нет презентации? Хорошо, вот это вперед, это назад.
Dear participants of our roundtable, let me introduce myself. My name is Gorbunova Tatyana Vitalyevna. I'm the chief expert of the National Institute of Intellectual Property, and now I'd like to talk to you in my report about the activity of the organization that the government named as the Expert Organization for the Restoration of the Intellectual Property Products on the territory of our country, including such items like intellectual trademarks. So the name of the expert organization, the full name is RGP. It means that this is the National Institute of Intellectual Property under the Ministry of Justice of the Republic of Kazakhstan, and I'd like to know that the institute itself is located in the capital of our country, in Astana. But in Almaty, there is the only branch of our organization in our country, and I hope that the number of branches will be growing. So, what I want to tell you is that over the past 100 years, Many countries of the world develop the intellectual property and protect it, especially when it comes to the training of, when it comes to the first days of our independence. There was a Kazakhstan and Patent Agency whose successor in 2000. In 2000 was the Institute of Intellectual Property, and the purpose of our institute is to provide expert services for the key types of the activities, both for individuals and legal entities, both for residents and non-residents of our countries, on the equal footing. There is no advantage of where the applicant is from what country. The institute is the institutional organization and authorized body of the Ministry of Justice of the Republic of Kazakhstan. There is an authorized body represented by the Ministry of Justice that solves certain problems by the expert organizations that perform expertise of intellectual property. For registration and keeping the register is the National Institute of Intellectual Property. What are the key functions of this institution? They can be split into big blocks. The first block, I will come back to this, is the acceptance of requests that are formed under the standards of our country. There is a legislation as per which the requests are formalized, the existing laws and bylaws, and then after the acceptance of the requests, there is an expertise, the formal expertise and full expertise, and there are items of intellectual properties that have the formal expertise only. And the third big phase is the registration, bringing the trademarks in the state register and issuance of the protection documents to the applicant. I'd like to show you in the slide, which is called Kaspatent.kz. You can find the state register. Any actor can go to our website to the section of products and see what kind of intellectual property items have been registered, and then to do search. Once the request passed 3 phases and it's included in the register, the right holder and the owner of trademarks may have the intellectual property rights, including for different signs. Okay. So the flagship is of confectionery as well as foreign trademarks. Different trademarks are registered in different way, not only in verbal form, in graphic forms, so with names and color forms. For example, the smell of the grass was also registered. There are also the sound and sonoric signs. And there are 4 sound signs have been registered on the territory of Kazakhstan. Well, I just want to show you 10 the most expensive brands in Kazakhstan that takes place from place 1 to place 10. So these signs have been as evaluated and assessed in a strong way in monetary equivalent. So in order to provide for the paperless work since 2016, the expert organizations introduced the personal accounts for all the requests for all intellectual property items, including for trademarks, to be submitted in the digital form, in electronic format. It's very convenient for the applicants, not only of our country, but also of other countries. But I'd like to tell you that the foreign applicants cannot submit their requests file their requests directly. They must do that through the patent attorneys. Today there are patent attorneys that are represented by more than 200 firms and individuals, and the list of patent attorneys are available in in igaf.kz. Today we can see all representatives of the patent attorneys who from the first day of a patent agency developed the legislation, filed their proposals how to improve the existing legislation in the intellectual property domain. Well, the personal account is also available in the expert organization of Kazpatent.kz, and any person can submit a request to register their items 24/7. I mean, with no weekends. So, but the date of request submission will be set according to the law of the working days of the Republic of Kazakhstan. Despite that, even if you are at home or at office, can see the paper flow in the personal account that is located in Kazpatent.kz website. The expertise for trademarks, and not to mention other intellectual property items, is 16 months. The expert for example, in Russia, getting document takes 2 months from the date of submission. In Uzbekistan, people say that there is also the fast registration of trademarks, but in our country is 6 months, and this term cannot be faster. In 6 months, the expert organization should submit the authorization of the registration of trademark or rejection, and in order to get the if they get the rejection, they have to provide grounds. And then goes the next phase of challenging this decision is the appellation court in Astana, and the appellation processes take free of charge, but the preparation and hearing in this process must be associated with certain costs. And every year the institute improves its software for searching works for expertise, but also provides provides more opportunities for the applicants, for them to know the registered intellectual property items in the state register. And since 2018, the Institute of the State Register published the requests for trademarks, and the term of expertise in Kazakhstan formally is 1 month with the amendments of 2022. Before 2022, the term of formal expertise was 15 days, and since last year, 1 month only. In 1 month after the request was filed and passed formal expertise, and the applicant received a notification of successful expertise, his claim is located, his request is located in Kazpatent in bulletin, in a form of a bulletin. This bulletin is not the search. It's not a paper that can be searchable, but he will be able to see the request submitted for a specific period of time. So besides that, besides the expert works, YOP organization as well as others perform their rights. YPO, they need to fulfill the Madrid Agreement, the Madrid Protocols, and other documents, Eurasian conventions. There are Eurasian intellectual property rights items that include the inventions, prototypes, and the Eurasian trademark can also be created, but it has not been created so far, and still there are developments of the Eurasian trademark that would be valid in all Eurasian Union countries. Well, besides such global objectives, the Institute provides consultational services. There is a call center, and the phone number of this call center is located on the website, and you can get answers to your questions free of charge. And we also have the feedback with CEO part, and you can go to the CEO feedback part where you can find answers to many questions. For in multiple years, there is already an experience how to submit the request, what kind of classificators to be used, and the applicant in the section of the CEO feedback can find many answers. So in addition to that, the expert of the experts from our institute are attending many roundtables, and one of the seminars is very useful. We learned there about the emerging trends, some features about 9-class products, and I will be talking about 9-class products with respect to statistics of what has taken place this year. And another activity of the institute is the involvement in the judicial hearings. I would like to add that RGP NIIS Institute, as the public organization, is involved in public hearings on a free of charge basis. A specialist is assigned that answers the questions in writing form for such cases. The institute performs the comparative analysis. The comparative analysis is performed for such items, development of comparative of prototypes, and by request of the stakeholders, the comparative analysis is performed. I'd like to know that over the past year, starting from the end 2022, the involvement of the institute increased in tenfold. There were some pandemic issues, COVID things, and there is a new splash for that. Every judicial hearing requires this comparative analysis, and they are not so strong in intellectual property rights. The both sides can be right. That's why they go to the institute services, and these works are being performed on a paid basis, but within the tariffs, they are affordable. They are affordable nonetheless. And I would like to tell you that mostly these litigations take place with the with unfair use of the trademark without owner, and again, or canceling of the landmark unless it is not used. But very lately there are some judicial hearings, not between the owners of the trademarks, but also with the different owners. We know that copyright is not subject to registration, but they can submit the information of their facilities that is located in the expert organization website. And there were some cases when they called out products with the names that were registered as the trademarks. And there are also the claims between the copyrights. So the requests are like that. So the requests can be mixed with each other, and how they can be distinguished. There is a Ministry of Justice. There are systems of mediation for reconciliation and settlement of the parties. Every of the methods to protect the exclusive rights are efficient in restoring the violated rules, and having a wide range of rules. The punishment can be applied, and there can be even a criminal responsibility, because the criminal code of our country provides for the statements that can be used in relation to the violation of the registered trademarks, along with other intellectual property items. So against the judicial practice, I'd like to tell you how to get involved in the judicial hearings. When one of the party does not come to the court, the court decides in favor of those who attended. So our applicants, our right owners should bring all the grounds and proof that they performed all expertises and have to compare the comparative analysis that RGP NIIS requests. So today there are huge opportunities for business development in Kazakhstan, but at the same time you have to keep in mind the following fact that the institute provides the support in an accelerated way, in a fast track support. For example, the searching works is done for the intellectual property in a more affordable way for the manufacturers. So the institute may perform the search works within one working day. There used to be 10 or 20 working days, and now it make the process faster. But there are different types of support that can be done within one day. All these tariffs and terms allocated in kaspatent.kz, and that's why we urge on all of you to use our website and in a relevant mode. The information can be provided there. So when it comes to the intellectual property of the meta universe, and the new products appear, like FTP is a non-fungible token, a unique, undivided, not interdependent digital signature. There can be different pictures, there can be different soundtracks that are independent. So there is a small statistics of how many items there are in the market and the price of them. So I want to tell you that currently these items are considered class 9. This seminar was dedicated to, but we got used to seeing the classification of trade of products and services. We got used to that, to class 9, class 35 to classes 1 to 35 are the products, and class 35 to 45 are the services. The services that belong to class 9 have increased. So if you compare the previous year, class 9, with this year, the number of those products increased. The products that we haven't heard about increased production of films, for example, movies, they pertain to class 9 as the product. In this diagram, I'd like to give you the statistics of how many products were sold, but it has to do with the national database. And Kazakhstan, like many other organizations, registration is possible in two systems, both for national and international systems. For the national database, we see that starting from 2022, the number of requests that are filed to class 9 increased twice, and this items appear, and we will be able to see the results of this request 6 months after, by the beginning of next year. And if VOIS plans to allocate these products from class 9 to separate class, it would be convenient to add the subclass, but not to refer them to class 47. So the ones who are working in this sphere understands that from class 9 the class of services starts. When class 9 the new classification appears, there should be a new classification in class 9. So the reason why we wanted to allocate these products from class 9 to separate classes or subclasses the way it can be done, because class 9 is a versatile one. And just imagine the expert on the law, the ones who do the expertise of those products, and furthermore the products will be added that pertain to FLT technologies, but they are not homogeneous with respect to the products that are in the class 9. So, for example, the volume of this the quantity of this work will be growing. There can be some conflicts of other items that are in class 9. So I would like to give you the statistics. So here, 3 times increased 3 times, and I would like to give you the following figures that today on the territory of Kazakhstan, for the national system, there are documents, and there are 3,000 patents, and in total 1,000 are the industry prototypes, and 60,000 trademarks, existing ones. And today, starting from 1990s, there are 82,000 trademarks. 1/3 of them are not working. 38 names of the products since last year, and in the year 2022 we have a new intellectual property geographical indications that are entered into the state register. So that was an activity about the state, especially for the registration of intellectual property rights. And we would like to tell you that even today, if we don't have the allocation of new products from class 9, the institute is ready to accept this request. And furthermore, when the request for trademarks is submitted, you can provide the application, and the applicant, when he sends a file with request, then he can prove that his product is of this kind or that kind. It will be taken into consideration with the expertise, and he can provide information on the item for experts not to spend a lot of time on the internet, and they will have no problems in understanding who they belong to. That's it from my side. Thank you. So now we can answer your questions if you have such.
Absolutely. Thank you so much, Ms. Grubunova. Your presentation is fantastic. It not only encourages the national choosing the IP office for protecting their IP rights, but also the foreign owners to choose the IP office using the tools you provided, and being updated about the information concerning your IP office. Thank you so much for the presentation. So now I'm gonna call to the floor Ms. Barbara Porcario. She's Vice Chair of INTA Emerging Issues Committee. So Barbara, thank you for attending this webinar online, and the floor is yours.
Thank you very much, and thank you for the invitation. I would like to share my presentation. Hold on for a second. Let me see. Okay, so I think that you can all see the presentation. And yeah, my name is Barbara Porcario. I am in representation from INTA. I'm the vice chair of the Emerging Issues Committee, and I'm from Argentina, Buenos Aires, and I am partner at Chaval Porcario San Juan. So let me tell you a little bit about what INTA has been working on the last term, last year and this year. And I'm going to introduce you to the work that we have been doing. And I'm going to start by letting you know how, in terms of practice, the trademark filing in Metaverse and NFT is around some of the trademark offices and is being registered. And then I'm going to talk a little bit about the protection, IP protection in the Metaverse. And I'm going to give you some examples of what's going on in the legal perspective from the case law. Then I'm going to summarize about the white papers, the recommendations, and the board resolution that was issued last term. This year in March, and then what's coming next. So in regard to the trademark filing and the best practices, I've been listening very carefully about Class 9, and I have to say that Class 9 has been one of the most eligible classes for trademark owners in regard to metaverse and NFTs and digital assets and virtual assets. So Class 9 has been one of the classes that all trademark owners that are incursioning, that are involving in metaverse and NFTs are selecting, and they are registering in that class, mainly in Class 9. And WIPO's approach, I think that we've discussed about this. They have the downloadable digital files authenticated by non-fungible tokens, by NFTs, within their classification. So that's right now, this has been approved. So it is a kind of related also to the virtual goods and the metaverse. So this is why a lot of, you're going to see now with the examples, how trademark owners that wants to commercialize virtual goods in the metaverse are registering in this class with this kind of descriptions that I mentioned. And of course, there are other eligible classes, and now I'm going to give you some examples, which are Class 35, which is often used for the marketplace for NFT platforms like OpenSea's, Rarity, and then, of course, Class 36 for electronic transfer of NFTs, electronic transfer of NFTs via blockchain, financial transactions via blockchain network. Class 41 is less eligible, and it's mainly chosen because it includes the training for NFTs, educational purposes, but it is not the most eligible one. And we have also Class 42, which goes, in my opinion, it goes by hand with Class 9. They are very much related. And Class 42 is a common class for non-downloadable software for accessing, storing, trading, and buying, and other activities related to NFTs. And as I mentioned, these classes where NFTs most often merge with other metaverse areas. And let me give you some examples. For instance, one of in L'Oreal, one of the companies, cosmetic companies, it's a key player in the cosmetic field and perfumes. It has a mark register, which is Redken for metaverse. And as you can see, it mentions in class 9 downloadable virtual goods, namely computer programs, products, and facial care products, and it continues, but I want to point out the mentioning of downloadable virtual goods. And this is very common for these companies that are getting involved in the metaverse to protect their trademarks. And of course, you're going to see that also this company, L'Oreal, filed for other classes, the ones that I mentioned, 35, 41, and class 3 is of perfumes. Then we have Hermes, which I'm going to talk about later, about the famous leading case, we can tell. And also it filed for a trademark of crypto NFT metaverse trademark application in class 9, downloadable computer software for trading, viewing, storing, and or managing virtual goods. So you can see that they are mentioning these companies that want to get involved in the metaverse and NFTs and crypto. They are mentioning expressly virtual goods and digital collectibles, cryptocurrencies, and non-fungible tokens. And this has been accepted by these trademark offices. In Argentina, we have a trademark to identify NFTs, and the classes where this trademark owner chose to protect its goods, it's class 9, 35, and 41, as we mentioned. So what happened with other countries? You're going to see this in the white papers that I'm going to share with you. But I only mentioned some of them, and you're going to see that some countries do not have formal or political guides in regard to the examination of the terms and of the goods, and they decided to render the approval of the goods on a case-by-case basis. And for instance, in case of China, China does not accept trademark applications related to NFTs. And Singapore approved a list of goods and services that include those related to blockchain technology. So these are some of the countries that has adopted some kind of, some of them did not adopt policies, and other, you can see that they have. And I think that we can reach to some kind of conclusion here that it needs to an harmonization to determine a policy in regard to this classification and the terms of the goods that wants to be identified. And let me give you some examples in regard to the case law, what's going on right now from the legal perspective, from the what is happening with the trademark enforcement of rights, and what is happening with the classification. You're going to see that it raised some issues in these cases. If you want to, for instance, enforce trademarks that are registered in the metaverse or in the NFT. So that raised a lot of questions and a lot of issues that have been mentioned in the cases that I'm going to talk about right now. And as you can see, perhaps you are familiarized with these pictures. The first of them is the Meta Birkins, the Hermes versus Maison Rothschild. Maison Rothschild is an artist who commercialized in the NFTs platforms, OpenSeas NFTs with a design of a Birkin bag. And it not only used the designs of the Birkin bags, but also the name Birkin, and he also registered the domain name metabirkins.com. So when Hermes realized this use, it filed a lawsuit against Rothschild, and it alleged that he was infringing his trademark rights that were registered, and also that it was a cyber squatting because it has the domain name with a Birkin registered, and also it led to confusion among consumers, which is against the Loyalty Act, this kind of use of Birkin. And what is interesting in this case is that Maison Rothschild wanted to, and he invoked the First Amendment of the US, which is freedom of speech, and it protects artistic creations. But in this case, the judge said that it was not applicable, the First Amendment of the US Constitution, and it determined that it was a trademark infringement because Birkin had its mark registered, Hermes had its mark Birkin registered, and Maison Rothschild infringed the Lanham Act. And also it caused dilution. It's a well-known mark, Birkin. And also Birkin, the design of the bag, as you can see in the USPTO, it was registered. It's like a trade dress that was registered. So the jury determined that Rothschild had the intention of generating confusion as to the source of the NFT, Meta Birkin, and it also committed cyber squatting. So one of the issues that we can summarize, and that INTA also addresses in the white papers and the recommendation, is the enforcement of registered trademark in the metaverse and the protection of artistic work and the boundaries. At the time of the white papers, we had not had a decision, but now the case has been solved, so we have the decision. Then another case which consists of the liability of the NFTs marketplace, and address that issue is Jusan. I don't know if you can see the artistic work of a tiger receiving his shot of vaccine, and this was protected by a copyright. These images and this work of art was protected, and Shenzhen, the plaintiff, had a license to commercialize and to use this kind of art, and realized that it was being used in the NFT marketplace to identify the work and the copyright. So it started a lawsuit and determined that he had to be held liable, this NFTs marketplace, because he had the duty of care and legal responsibility to avoid this kinds of infringements. And also what it's important is that it had a lot of economic benefit. So he was actually held liable for copyright infringement and ordered to pay damages. And what is interesting in this case is how we enforce a cease of use, for instance, in this kind of platforms. It's like, I don't know, but it reminds me of what happened in the internet, when internet came to our lives and changed everything. So what happened is that, you know, that NFTs are based on blockchain. So the court determined that it had to be removed, the original blockchain link to the infringing NFT works, and then deliver the same to an inaccessible address, because it's very difficult to accomplish this kind of court decision in regard to NFTs. So this case is very interesting to see how the liability of NFT marketplace, this role, and how it has been, this is in China, interpreted. And then one of the other cases, which is pending, and I look very much forward to see what's going to happen, is the case on Nike versus Stock. StockX started selling these NFTs that you can see there with the images of Nike shoes or Nike articles. And it used these designs, and its StockX was using the NFTs to authenticate the physical good that was being stored by StockX. And not only he did that, but also he promoted, and it gave benefit like fidelity with the clients and other benefits when the client decided to redeem that NFT with a physical product. So when the client had the NFT and bought it, he can say, okay, I want now to redeem it, and then StockX sent the original, the physical good to the client. And when Nike became aware of this use, it says that it was infringing his trademarks because he did not authorize that kind of use. And also it was competing with Nike because he wanted also to launch his own NFTs to the marketplace. So in this case, what has been in the complaint, and you can see in the lawsuit, it was it has to be interpreted whether it is an artistic work or it can fall under the fair use. But in this case, Nike did not endorse nor authorize any kind of use. So we don't know what is going to happen with this case because as we are speaking right now, or as am I speaking right now, there's no decision. And the issue in this case is the application of existing standards of fair use from the physical world onto the digital tokens. Another interesting case, it's Miramax versus Quentin Tarantino. This case was settled. So, and it was settled, it was filed, the settlement with the USPTO, but with the court, but we don't know the terms of the settlement. And in this case, it was a contract signed in 1993, so a long time ago, of Tarantino and Miramax. And Tarantino had reserved rights to the soundtrack, album, music publishing, live performance, print publication, including screenplay publication, making of books, of interactive media. So he reserved the rights to the screenplay publication, and what Tarantino did in 2021 is launched an NFT collection which consisted of digital images of portions of the handwritten version of the Pulp Fiction screenplay. These NFTs were auctioned on the NFT exchange OpenSea, and Miramax sued Tarantino for breach of contract. And now it plays a very important role in interpretation of whether this screenplay publication involved or included NFTs or not. Because NFTs did not exist in 1993, of course. But we don't know that, the interpretation, because the case was settled, as I mentioned. And let me go to the other case in England, Amir versus Nifty Gateway. This case is in regards to, it's important because we have to see what's happening with the terms and conditions and the contracts in the marketplace. In this case, Amir, the plaintiff, placed a bid of $650,000 for a blockchain-based NFT associated with an artwork, as you can see in the left, by the artist known as Beeple. Mr. Amir bid came in third because it was a ranked auction. It was not a conventional auction, but he misunderstood and he thought it was a conventional. So he did not get the first edition of this NFT. He got the third edition. And what he did is he didn't want to get the third edition, and he said that he should have won and had to have the first one. And so he withdrew the cryptocurrency from his account to avoid paying. And Nifty commenced an arbitration against Amir for breach of contract and payment of the bid amount. So in this case, Nifty invoked the terms and conditions and the contract signed between the parties with his getting into this marketplace. And the English court determined that it did not have the jurisdiction and the NY arbitration should apply. But as this year, it is recent, Amir appealed and sought nullity of the arbitration clause. Court of Appeal allowed the appeal and ordered a separate trial on the issue of the validity of the arbitration agreement. So as we are speaking, we don't know what's going to happen with the terms and conditions and the contract signed within these platforms of NFTs or auction in between the parties, whether they're going to be valid, whether they're not going to be valid, how they're going to be implemented, and what legislation applies to them. And the last case is soccer. Soccer player Juventus, it's a well-known football club, versus Bloqueras. This is a recent case also last year. Bloqueras sold NFTs with the images of Juventus soccer players, in particular Christian Vieri, whose image was used within the limits of the license agreement with the company that managed his image right. But it also exploited the trademarks that were in the t-shirt and that were the labels. And Juventus filed a lawsuit seeking cease of use. What's interesting also in this case is that Juventus also wanted to start launching NFTs and starting to play a role in the NFT field. So the first instance court ordered Bloqueras to stop commercializing NFTs portraying use of the registered trademark of Club Juventus. And what happened here is that the court held that the trademark Juventus is well-known mark. So this this unauthorized use shall cause a dilution of the mark. But also what happened to the registered trademark? Juventus had the trademark registered in class 9, but it did not mention NFTs. It was broad, but it did not mention NFTs. So the interpretation was, does Juventus have to file another trademark, or we can be flexible enough, or the court can be flexible and interpret that it is actually NFTs are related to the goods covered in class 9. And that was what the court held in this case. So I'm going to go right now to the INTA's white papers and board resolution and the recommendations. So I think that this case law and the practice of the registration trademarks that we've seen, this INTA became aware of this, all these cases, and it became aware that the technological developments resulted in emerging digital ecosystems like blockchain, NFTs, virtual, augmented reality, metaverse. And it raised a lot of questions that INTA has been working with the Committee of Emerging Issues, which I'm part of, and the subcommittees and 16 other committees to address all of these issues, or some of them. So the Emerging Issues Committee and the subcommittees, in collaboration with others, which were 16, released and advocate the publication of the white papers on NFTs and trademarks in the metaverse, and the board resolution, which was issued in March this year. So there, I'm going to then share the presentation so that you can access to the link, or if you want, I can send it to you by email. These are the two, you can find here all the NFT and metaverse white papers, which are 80 pages, one and 100 the other one. So it's long, but it's very, very interesting. And then as a result of that, we were very happy to have the board resolution issued and approved this year in the intellectual property rights and new digital ecosystems. So I'm not going to, these are the chapters of the NFT white papers and the metaverse white papers and the issues that they address. And let's go to the recommendations that are very important in regard to the classification, harmonization among trademark offices. Globally would greatly benefit trademark applicants and trademark offices in enabling applicants to both protect the trademarks for NFTs and to maintain the resulting registration, proving use and defending against non-use cancellation. In order to do so, the best practices include filing in class 9 for the NFT digital token and ensuring that the trademark appears on the face of the digital token and or the access, download, or purchase screen associated with it. The majority of jurisdictions consider the digital token itself to be classified in class 9, as we have seen already, and as such, obtaining a registration in class 9 is likely to be the best approach for obtaining protection right now. Of course, we don't know if there's going to be another class like class 46 or what is going to happen. But right now, we recommend to have them registered in class 9. Filing in class 35 is also recommended for individuals providing platforms and outlets to sell NFTs. And also, INTA recommend that all jurisdictions consider a harmonized approach for classifying NFTs, potentially through providing new language through the NIIS classification system. And last, we can mention also the board resolution, which you can all see, but I think that we're running out of time, so I'm going to be a little bit more quick. So we have the board resolution determines that intellectual property is capable of existing and being exercised in emerging digital ecosystems. And as such, it has to be respected in said ecosystems. National and international laws and treaties for the recognition and enforcement of IP rights should apply in emerging digital ecosystems. To the extent that IP may be protected by more than one type of IP right, enforcement of some or all applicable IP rights should be permissible in emerging digital ecosystem at the discretion of the IP right owner, and to the extent practicable, a harmonized cross-jurisdictional approach should be developed for recognition and enforcement of each type of IP right in emerging digital ecosystems. So that's pretty much it. I'm going to share with you then the presentation, and I invite you to read the white papers.
Thank you so much, Bahram. Your presentation was amazing. Unfortunately, we don't have much time extra, but now I would like to open to the questions of the public. So the audience would like to chat up or take the floor to provide any comments and do a question.
So I have not a question, but the comment to Yuri Albertovich presentation with respect to the languages. I used to work in the expertise of trademarks in CAS patent, and I remember that hieroglyphs of in Russian Federation were treated as images, and probably I think the Kazakh patent authority will do the same. They were classified as per the Vienna classification of elements, and we were sitting and studying these hieroglyphs. You know, like we never translated, we never perceived their meaning. We only treated them as images, and we could compare one hieroglyph with some other hieroglyph that looked very similar, in particular with the dot or with the comma, but after your presentation I think that they may have different meanings, and our Chinese colleagues that have this preliminary denial would believe like, oh, in Rospaten these people act like crazy, but when I stopped working here, when I was working in the patent organization afterwards, we were supporting this side of the client. For example, the Latin sign of Everest of Chinese was given. We received a denial with hieroglyphs that turned out to be even the meaning of Jumalungma. So they may mean the same meaning, but in Everest it's like this, and in Chungmalungma it means in hieroglyphs it means Jumalungma, but in China it sounds this way. But when the trademarks in China are registered, you should not only check the hieroglyphs, but to translate them. When Chinese colleagues come to us, I think that's the point that it makes sense to deliver them in both languages. So I also had an experience where the information was given in the hieroglyphs like, I welcome you, the traveler from a far country, and after that there was a phrase like, please go away, the strange foreigner. So these hieroglyphs are indistinguishable for those who don't know the meaning or sounding. That's why the distinctive capability of even the ones who know how they work of different hieroglyphs is doubtful. So sometimes you cannot either understand or find the distinction in between.
Thank you so much for the questions and the comments and the clarifications. I also would like again to thank you all. This is an amazing opportunity to discuss IP and to provide more information. And I would like to thank you, Mr. Bolotov, and also Ms. Gurbunova, and Ms. Porcario for the presentations. I thank you so much.
I think that now we have in Almaty, Astana time, I mean in Kazakhstan, the lunch break, and we will make the lunch break, and we will see each other a little bit later according to our timeline. It is 15 minutes past 2 local time. I'd like to thank you very much for the moderating and for the presentation. Dear colleagues, my name is Zanat Nurmagomedov. I'm the partner of the legal company Bolotov and Partners, and I replaced our permanent moderator Yuri Bolotov, and now we will have the next session dedicated to marketplaces that Dmitry Marakanov will moderate. Dmitry is a managing director of Patentus legal company, and he also contributed a lot to this. So now the idea of the roundtable proceeded from Dmitry, to be honest. So Dmitry, the floor is yours. Well, thank you very much for this opportunity to speak, and thank you very much for this opportunity to have this joint idea, I would say, in implementing this idea. And I'm happy that we managed to do that. Thank you very much for all this. Everything is organized in an outstanding way. There are insightful speakers, especially in the past section. Okay, and coming back to our section, I'd like to tell you that the key problem fighting with fake products used to be the clothes market in Cherkizov and other markets, and every city every country has such a market where the right holders cannot come. When raiders started, all people knew about them, and there was a big deal, there was a big problem, and then their popularity decreased, and if they exist today, they act as the platforms for small retail or tiny wholesale sales. The retail markets are in the internet now, and the internet has become a great problem because it's easier to fight with counterfeit products when you see the product, when you check the quality, and when you can buy this product, when you can do the test purchasing and initiate the relevant actions. And it's easier for the consumer to understand what product he or she is buying. And when someone goes to the Nike brand store, they will understand that the sneakers are original. And when person goes to the market, he has a very high level of awareness that this product is fake, and a person undertakes a conscious decision to take fake products. And it's difficult to deal with such cases because, as I told in the beginning, that the key to the problem of the fake products is that there are two categories of consumers. The first category of consumers, they don't know that they buy fake products, and here one needs to fight with the sellers, and the other group is those who buy the fake Louis Vuitton for 20,000 rubles, because 200,000 rubles it's too much for them. So in here we are talking about another thing, is changing the perception of the consumer and to the the awareness programs. And when it comes to the consumers who don't want to buy fake products in the marketplaces, the internet has become a place where you can't understand the quality of the product when you order it. When the product is delivered, it's difficult to detect, and sometimes it's too late to detect. And such a small background of those theme marketplaces, many marketplaces in post-Soviet Union countries and in international area, they replaced the internet stores. Internet stores had their own warehouses. They bought and sold products, and they were reliable for that. And after that, a new model emerged, the so-called marketplace. The marketplace is not the seller of the product, but acts as a mediator. It provides a place in the electronic platform, a place for the advertisement, for the ads of sellers. And now I'd like to split the classical and non-classical marketplace. Ozon, for example, appeared to be the internet space for books sales, and then it transformed into marketplaces. The same thing with Avito. Avito appeared to be the marketplace, the place where the sellers and the buyers can find each other. And so the relationships and judicial practice also changed. The marketplace, the internet store was always liable for the for such cases, and the same practice applied to marketplaces. The marketplaces brought to liability because the right holder finds it easier to sue with the marketplaces rather than to find every seller. And then the marketplace has the concept of the providers of internet communication that are not in charge of copyright infringement of information. So the same thing goes to marketplaces. So the marketplaces are not the case any longer. They are not the sellers any longer, but just they gave an opportunity for the seller to place their ad. So there are different opinions, legal experts and other specialists in former Soviet Union countries and abroad. There is no common approach that the marketplace should not be liable. In many cases, some marketplaces they act as a certain body that controls the prices in their platform, define the prices, provide discounts, provide certain guarantees to the consumers, provide services of packing, repacking, deliveries, and sometimes one has an idea that a person buys not a product from a seller but from a big marketplace, from a big enterprise, and I think that there is a certain approach. But globally, I can say that in addition to the great scope of work that we have done with the right holders on the one hand and marketplaces on the other hand, we see how strong the position of marketplaces and relations to fake products evolved, and what big job marketplaces are doing in this respect. And here I can give you any example. Almost everyone has violations, but any marketplace has a chance to block ads. And I hope that today we will discuss that we will share the practices of marketplaces, of how to avoid infringements, and what is to be done with the product sellers, etc. So, and now I'd like to introduce you the participants of our discussion. Today, there Aliya Adijanova with us, Jusan Mart, Leonid Gishulki, SKF, Pyotr Kodesh, Operator Associations, and Maya Lavrova Azan. So, I would like to pass the mic to Aliya, and Aliya will share with us the fraudulent cases in marketplaces, and that's a pretty relevant topic, especially today when we hear about the waves of microcrediting and all these things. Aliya Shanat, please, the floor is yours. As I understand, some of the participants will join from the audience. Okay, thank you very much. Good afternoon to all. Hello, everyone. So, there should be my presentation there. My name is Aliya Andrajanova. I'm the Jusan Mart legal expert, and today I'd like to talk about the frauds in marketplaces. Many people were talking about the fake products, but I want to go a little bit aside from that, and let me turn to the presentation. Jusan store is the store where you can buy different products and services of different prices. Through Jusan store, you can buy household products, electronics, and other products. You can register your purchases online. You can use a Jusan bank. You can use Jusan or any other banks, and you can pay by installments. And now let's turn to the idea. In Kazakhstan, there are increasingly more fraudulent cases as compared to in 2018. There were 517 cases of frauds in cyberspace, but in the year 2022, such a number of cases was around 2,000 cases, and there are billions of losses of such of infringements. And marketplace Kazakhstan was also the victim of such violations. The law enforcement authorities registered 5 cases, and one should note the fact that the legal and criminal cases take long in investigation. The file was submitted in December 2022, but law enforcement agencies don't accept these materials in a good way, and the investigation authorities have a clear impression that if the initiator of the case is a legal entity, then the cases are considered as the civic and the legal dispute. At the same time, it was claimed that the law enforcement agencies created the Department of Fighting with Criminal Cases. We went to the Department of Internal Affairs and also to the judicial bodies, and there are no theoretical or practical knowledge from the investigation authorities. Similarly, they don't have enough knowledge in investigation, but at the same time we need to highlight that in digital sphere there is enough materials that are well oriented and are ready to assist in investigation and be the part of it, but it's not that popular. And based on this experience, the investigation authorities are not interested in that, are not ready for that. The cyber threats are gaining momentum. In the year 2023, the number of frauds exceeded the number of cases in 2022. And in order to avoid the criminal cases in marketplaces, we suggest you meeting 5 banal cases that are well known but not used. First, communicating with the sellers only through official marketplaces chats, and pay the products only through marketplaces, and never follow the marketplace links, because the link to understand to check the information of the sellers, and when the seller calls you, never tell the SMS passwords or logins, never pass the verification codes or SMS even to call desk employees. I can tell you, based on the foregoing, that the safest way to communicate is to communicate with marketplaces. For Forbes, we take a place 8 in the magazine, but nonetheless we are the victims because we encounter frauds every time. But we ask the law enforcement agencies to be professional and keep the subject and object of the information that is on the ground. The legal experts from digital environment are ready to take 3 steps ahead to our judicial bodies and extend their hand to shake it, to accept our help, and start cooperation with us to avoid any further dissemination of crime and prevent the spread of cyber crimes and the development and the sharing of experience. But at the same time, with a certain irony of gratitude, I'd like to thank our fraudulents and conmen, because thanks to this revelation of crimes, we come up to logical things, and we introduce certain measures like a verification of legal entities, requesting for the compliance certificates. We verify the compliance of mobile phones, of the phone numbers, and we also reveal and we block suspicious cases without referring it, without aggravating it. So at the end, I can call on all of you to make purchases only on official websites, and I would suggest you avoiding any small and doubtful places. Aliyah, thank you very much for such a brilliant conclusion, like only work with us. Well, the key to success is when there are such platforms, when their quality is there, and that's good that you are, as a big platform, protect the rights of your consumers, and you feel your heart with them, and you concern what they are doing. There are different types of fraudulent activities when consumers get consumer credits to buy online products, and the banks cannot fight with them because the procedure is takes place online, and banks are not technically involved, and there are costs that cannot be recovered. So I would like to enjoy my rights of the moderator, and I would like to ask you the question that is close to our topic. I'd like to ask if Jusan Mart performs any actions related to this fact. When someone joins the platform, do you ask him or her to prove for example, if there is something that registered, do you ask for the documents? And how often do you face this situation when a certain company says that the certain trademark is violated, and ask to remove this announcement? And how do you interact with the right owner? And how do you represent the interest of your colleagues, and how the procedure is established? Well, thank you very much. I'd like to answer this question in the following way. The first and second question are interrelated. The official right owners come to us. It doesn't happen that frequently. For half a year, 2 letters may come in our practice. And as a rule, the large right owner comes when the large right owner comes. They pass through the whole line of investigation. We check the certificates, etc. We reorient the right owners to the seller. Our trade platform allows us to do that, but we as a third party, we are always engaged in communication because we are interested in the fact that our sellers work officially, and their turnout would be less. And we also send a notification to the seller that such companies had the following claims, and such sellers send us the permission to cooperate with us and to use the trademarks. But it's pretty popular today, and the famous brands have no challenges with that. But mostly the challenges appear with small enterprises, small businessmen. But we see certain statistics that there are some sellers that answer automatically. There are some sellers that send the compliance certificates, and we keep them alone, but we inform them that such a message was there. And the cooperation takes place this way. Alia, thank you very much. And is there a policy request per which the right holders or the sellers may review this part, or you haven't been doing with that? At the day of registration, we have a number of requirements that our seller should perform. He, as the businessman, he should fulfill certain requirements and should have the certificate of compliance. We, as the platform, we need to respect that, and the right holders come to us through banks, and the recourse to us through bank has a different nature. And the wrap-up question from my side: is there an online service of interaction with which you can use, or where you can upload the information, something of that kind? You can access the online website. In our website, you can find all your contacts, emails, or whatever. You can use both your personal email, or you can use the chat of sales platform, and the response will be given to you in any ways. There are many ways for you to communicate, and they are very convenient for any seller, and yeah, for any buyer. Well, unfortunately, I can't see the audience, and I don't know if there are questions or not. Not, please assist me in moderating the questions from the audience. Probably we will keep the questions for the Q&A session, or what we're gonna do. Well, let us slightly change the format, because sometimes the questions are forgotten, and there are not so many speakers in our section. Yeah, I see that even you move the microphone. That's good. My name is Ainur. I heard you saying that you request the certificate of compliance, but I haven't heard whether you request the certificates of rights. But for example, there is a certificate of compliance, but he didn't take care of certifying the rights for the product. So first, the certificate of compliance is important, or what? So this is the guiding document for the property rights are not requested. Well, now we request for the certificate if the right holder comes to us, but there are certain exceptions for the trademarks. So when we understand that the sales can be done and at the entrance level, but the primary is the certificate. Okay, thank you. Certificate of the products sold. So the certificate does not guarantee that the person who sells this product, that the product is sold, that has been certified. So the copy that you have is just a copy that someone certified a certain product, and the one who sells may sell a different product and attach the certificate. So the call from the right holders to request the certificate where he got the product and request that this document is the original one. Well, thank you very much for your comment. I'll be frank in saying that this is the pain of the marketplace legal experts and fighting with the businessman, because we have different interests and it's difficult to find a golden middle in between. Good afternoon, my name is Ali Kaliyev, Synergy Partners legal company. I'd like to know your practice to understand whether we should go to you in future if our clients suffer from such unfair sellers. So do you give the statistics of the sellers who already sold fake products to the right holders and right owners to understand what kind of damage was inflicted? Well, we didn't receive such requests, but in case if such requests are there, then such questions are being dealt with. But in any case, we request that this request would be from the authorities, because this information is confidential and sometimes not always we can unveil the information that was requested. So RGP NIIS, well, this is not the question about your marketplace, but the marketplace Kaspi KZ is the popular one. So there are many cases when individual entrepreneur, some businessmen come to us that placed the ads in Kaspi KZ on their product. They provide products Chinese one, and they are revolting. I sold my product, but some other private businessmen sell my product instead of me, and I want to protect my rights. And the institute starts asking, like, do you have a request? Did you receive the right protection documents? But they answer that these are the Chinese products that were bought from Chinese flea markets. But they don't want to submit these documents, and we received a huge quantity of the requests, and in future they will be rejected. But nonetheless, there are cases like this in marketplaces. The sellers themselves, they use some other else brands and products. They told, like, we were the first to import these products, why someone else is importing instead of us? Well, sometimes there can be argues about the trademark even with the images, and we request the certificate or permission to understand who is from the seller, who is the actual right holder. We used to have such case. There used to be several blocked merchants, but I'm always happy when Kaspi from its side takes certain steps in this respect, because we are not so popular, but Kaspi is more popular. So while we were taking the steps like this, many sellers said we have a better platform, Kaspi KZ, instead of you. Okay, thank you, colleagues. From my side, I'd like to add that in the marketplace practice, the most important thing for them is to be more modified. This is what we need to share the experience with each other. So. We use the practice of all marketplaces across the world and their policies and practices in counterfeit products fighting. We created the manual, extremely useful instruction how the practices must be performed in the entry point in dealing with the product in such volume when the information is provided. So sometimes the right holder is in the difficult position. So that's why I would like to call on all the marketplace users to get into our practice and receive this information from the first hand, and even impact these practices with their own experience. Okay, just tell me please, Janat, if there are questions from the hall. Okay, and wrap up question, Shapalin and Partners. Well, you mentioned about the availability of 5 legal cases where you were involved in different cases related to the frauds, but then you told that there used to be the civil cases. And do you have any civil cases related to the protection of the legal rights where your company was involved as the third party, as the co-defendant of a case, and what were the outcomes? Were there any claims to you as the intermediary, or as the as the person who violated something? No, we didn't have such additional cases. We didn't have that. Only the right holders came to us and their answers were in writing, and all those risks have to do with the recovery of receivables, and our legal cases are within the article. Like frauds, the reason why I'm asking is that because such cases appear when the domain name is protected, when the co-defendant, as a co-defendant, is the company that registered domain names, and the company has a clear legal position, like we only provide the domain name and we don't check it. I think Leonid Yershulin will talk about it, about the responsibility of third parties. And I'd like to thank Aliyah for her outstanding talk. Thank you very much. So now I would like to invite Leonid Gershuli, SKF, and Leonid will continue the topic of marketplaces, such as informational intermediary. He will be talking about it. Apologies. There was gonna be the outlook of a layman, but before we go to the marketplaces, just a few words of what is happening in a strange market, the market that have problems. The bearing box market. The bearing box is a place, is a thing This, for those who don't know how it looks, with two rings and several balls inside, that is in every equipment, and it rotates, and its rotation means a lot, and there are many bad things may happen if this if this equipment behaves in the wrong way, as not as planned. When this beer box behaves in a different way, then the situation will be different. So we have a small comics on this topic. What happens if, for example, fake products appeared? So normally a guy comes to a company who says like, look, I have a cheap bearing box. It was either sold cheap or expensive, doesn't matter. It can be installed in the submarine, in the plane or whatever. And as if something wrong happens, then there may be a disaster when we have fake product. We can deal with that. We are fighting with this, and this is the common cause, not of only from our side, but the common cause of those who consume this beer boxes. Whatever we are doing online, because our main clients are the industries who buy beer boxes, gearboxes, and we are proud that we didn't have so many legal cases for the supply of beer boxes, and they were punished. Okay, and as a result, in an offline mode for 70 years, we decreased the level of fake products in our brand from 40 to 10% in the whole CIS region. Now we have less problems with them, but nevertheless they are needed. And now coming back to the sales of fake products in marketplaces, what we faced recently. We faced the fact that a very known marketplace in Kazakhstan was selling the beer boxes, and the idea, actually, we didn't ask, but the ones who were selling these beer boxes, we found that in marketplace they say that you can buy beer boxes from us. You put the gearboxes in your basket, you pay. Either you can take it from our shop, or the messenger will come to your office in the branded overalls of our shop. And me as the buyer, I don't really care whether I bought it from the marketplace or from some other shop. I ordered something, I paid for it, and he delivered me this thing, and the guarantee lies on him. And if I asked him to replace something, there was no difference for me. That's an average shop. Just not to mention the cases when I found an ads in Yandex, and then I followed this thing. No, I paid money to that guy, but nonetheless, we bought a beer box. We are happy, and we return it to the supplier. And marketplace said, "Oh, this is not our fault. We are not here to blame. Just tell us who sold you this, but we are not liable. Just go to the civil court, go into litigations with them, and the court will say like, if I'm forbidden to sell something, then we will do something about it." And so we never sell anything that, as strange it may seem, but the sales will be like that, taking money and selling products. This taking money and selling products is not the fact of sales, but okay, let legal experts be engaged in that. But this is the sales actually. So how the right owner sees it. So for us, as a matter of fact, if marketplace behaves itself as it behaves, then he's the involved participant, he's the actor of the supply chain, and he gets profit from the money that I saw paid for the fake products for buying gearbox. The marketplace gets 20 or 30% depending on the marketplace. So there is nothing new. I mean, it was not written whether it was fake product or not. So if it is sold from our warehouse, then it is original. Somewhere this manufacturer or supplier wrote it in a small font that you can request an information from the marketplace, request for the information, and ask for an L to bring him or her to responsibility. And the great majority of people see this. See in this fake products, it sees the partner in crime. When I was preparing myself for this event, I performed the question. I used the survey. I used polling, and 90% who answered this question, they believe that this marketplace is a partner in crime. And in addition to that, we had another problems. Okay, marketplace is selling fake products, but it's okay. But moreover, they harm the reputation because the requests. The reviews, sorry, the reviews are those who sell original products and those who sell the non-original products. All people write like, I bought the fake, and the gearbox was not working well, and then another person writes that I'm happy with this gearbox because one bought from one supplier and the other from the other supplier. So there might be different problems, there might be different damages of those gearboxes, and you cannot split in between. It doesn't really matter because the reviews are not marked like a good supplier or bad supplier. It doesn't really matter, but there is a practice of it. For example, in Amazon there was a practice like they tried to prove that, etc. But there was no will to do something about it. So the reviews is a thing that damage reputationally to us as the right holders. Well, I see the following thing. For example, in Kazakhstan it works like this, and in Russia there is a huge experience here. The legal framework has matured. And I know that there are less incidents here in Kazakhstan, and the good thing is that we heard the INTA's recommendation of how to avoid the selling of the fake products if they don't want to be those to blame in the chain. But a clearer, there should be a more clear regulation of those who use this thing. So who is to blame if something goes wrong? What is to be done by marketplace? The sufficiency of measures to avoid these problems. Okay, what is to be done if there are claims? So the responsibility and liability for not taking measures. So the supplier sells fake products, but they don't do anything about it. So this is the conscious deviation, and how to calculate the costs. But when we do the physical rates of clients, of the supplier, just if you want to check how many products there are in the market and how many products are on the shelves and how many products were sold. This is a secret information, you never know about it. And another thing to keep in mind in the Eurasian Economic Union is transboundary case. For example, we know that there are many right holders in Russia that are not actively working there, and for some brands, at least in some online stores, there are shelves full of fake products, and these products come to Kazakhstan. And when we are in Kazakh jurisdiction, we want to protect ourselves, and marketplace says us, and this is not us to blame, go to Russia, there is a store, we work with suppliers, and we are not to blame. It doesn't really matter what happens there in Russia, but what matters is the picture here and what is to be done, what to do for this suppliers we can't impact, how to protect ourselves in this regard, how to get it right to avoid the appearance of fake products in our case. So if all marketplaces behave this way, and if they they will be sabotaging all our efforts, if we don't, we will come back to the euro when the marketplaces are a safe place. Okay, Leonid, thank you very much for that. Thank you very much for very emotional talk. And me, as the representative of the right holders, I understand your pain. I understand that you concerned about it. You were right by mentioning many of these issues, and some of the issues have been resolved on the international level. There are certain concepts, but we don't have an idea that all marketplaces are bad ones. But there are also good ones. Let us think in a different way, because they want to make life better. They want to make difference, and there should be a balance with the chance to earn. And okay, thank you very much, Leonid. Whatever you mentioned was timely and was very useful, and you can also come to our events, you can attend our classes. We have a good practice of market places here, and some of the people starting changing their attitude, and most importantly that the business from one side and from the other side going to find the win-win rules. One business should not harm the other. Well, so thank you very much for that. Unfortunately, I won't give a chance to answer your questions, because online monitoring is not an easy thing when you do online moderation. And now we started with marketplaces, then the right holders, and now I would like to change the consequence, and now I'd like to hand it over to Maya Lavrova, the representative of the community, and the marketplace can answer the criticism in their regard. But you can say like we have a different technology that prevents from fake products appearing in the market. Okay, Maya, please get connected. Good afternoon. Can you see me? Can you hear me well? Thank you. Thank you. Outstanding. Fine. So great. Now I would like to share my presentation. And okay, colleagues, good afternoon to all. I have already been introduced. My name is Maya Lavrova. I'm managing the legal support of Ozon Marketplace. Well, and today I would like to share with you the experience that I have in my company when dealing with the sellers that are engaged in selling products, and they have questions related to the intellectual property. One moment, please. Now I need to understand how to share. Okay, Maya, there's no point actually to share something. That's fine. I'm sitting in front of the computer and I can see your presentation well. Okay, then fine. Let's do it this way. So you can press Control L. Control L. Yeah, Control L. Well, it doesn't work for me. Then okay, let's spin it, and if you can do that, okay. Okay, let's do that. So I think nothing goes wrong with that. Okay, so the topic of my presentation is the mistakes in dealing with that in marketplaces. I would like to have a different look at that with respect to the issues in intellectual property rights when selling the products in marketplaces, and how the marketplaces see the their involvement in dealing with different problems. And I'd like to tell you from the beginning that I will be guided by the system of Russian legislation where Amazon's marketplace, the key one, is operating. And I believe that the key problems and issues are applicable to any marketplace in any jurisdiction. I will talk about Ozon Marketplace very shortly. Ozon was already mentioned, and Dmitry was talking the way marketplaces evolved from the first day of appearance. And in Ozon, there was a story when the large store that was working according to conventional retail store decided to take a new model of sales as a marketplace, and instead of buying products from somewhere and selling products on their behalf as the seller, Ozon has become a platform that brings together the sellers and the buyers and act as the intermediary in between. The marketplace appeared in 2018. In the middle of 2018, first there were not so many sellers, but the sales model was pretty successful. And now, 5 years later, we have 3,000 sellers in the marketplace that sell around 200 million unique positions, and around 10,000 sellers use our personal accounts of that protect their owner rights. And it's obvious that there is a great quantity of the products of the intellectual property. Um, Intellectual property items, so that's a great variety of them. There is a huge competition in between, but in this or that way there are many issues on how to resolve the disputes of using intellectual property when dealing with the products. And now just very briefly for the key issues and problems that the sellers encounter when they enter the marketplace and what kind of solutions they have. I think the key issue and the key problem when what the sellers make when they only start, they perceive the platform as the big internet online store. If they start selling something through the marketplace will deal with their problem. And when marketplaces appear, the sellers always put their blame on sales on the marketplaces, and for a right holder it's easier to go to the marketplaces because they're the big holders. They will never disappear, and in case when something goes wrong they will get compensated, as compared to the violations of small businessmen from whom you will never be compensated. But this is the approach that was not successful at all, and now there is a practice on which the marketplaces are not brought to the reliability and responsibility if they violate something. Why it happens? One needs to understand that many marketplaces, including Kazan, works in a way that the sellers should define themselves. They should create the cards of the products themselves, place information on them, and marketplaces as intermediaries, they place all this information with a minimum level of moderation, and the moderation is aimed at the visual part to make everything look and sound beautifully, but no documents requests that certify the right holders are never requested, and that's obvious. You can see that millions of SKUs can never be verified. No marketplace will be in the position to verify that huge quantity of different SKUs. And also, given the fact that the marketplace platform only provides for a chance for sellers to place their products, there is a successful practice when marketplaces are considered as the informational intermediaries or media intermediaries, and these institutions are guided by the code of the trade code of Russia, where people can place their products and be guided by this code, and in order to enjoy the right to not be liable for informational for any issues. If the right owner comes with a request for a specific material that is placed on the site, they need to take measures against them if such measures are taken, and if there are further litigations, the the media mediator is not brought to responsibility, but the person who placed this information. And now how it looks in practice: if the right owner sends the claim to Azan, who provides the information that this person has the right to use a certain trademark, Azan only hides this product card from the site and requests the information from the seller of what has happened, and if the seller can provide the information and this product was bought from the direct right holders, he may show the mail trail, then the product will be returned to the market. If such documents are not submitted, then this document will be still hidden, and there won't be any violations. So there were many litigations with respect to this issue. Like I told, Azon Marketplace was launched in 2018, and the peak of different cases was in the year 2021, 2022. There were different cases, but we managed to protect our position that we are just the media intermediary. And the case that you can see in this slide, despite of being in the first instance from Azan, the compensation was recovered. This ruling was abolished, and now they consider the informational intermediary. All right holders understood that there is no point of bringing the platform to liability if all the measures are taken. This probability that something will be recovered in the court tends to go down, and the practice is there, and marketplaces have the status of media intermediary. And as a conclusion, I can tell you that that's really important when you access marketplaces, to keep in mind the probable responsibility and do necessary checks before place certain products in the market to avoid any problems with the right owners. And marketplace in this case will never help the seller because it's a media agent. Another mistake I want to mention is that there is a fail to check the brand before entering the marketplace. That's backside of this story, because the ones who deal with this business story, they have a different opinion of the entrance process, and for them the speed matters. Because, for example, if the businessman finds a product, for example, somewhere in China, and he sees a huge potential in selling this product in Russia, so he seeks to place it as far as he can in the platform without thinking like this product has a different product. This product has a different product rights, and the claims may be there. And then it's sometimes very painful, because according to the civic code of Russian Federation, the win can be up to 5 million rubles, and indeed the values can be significant, because over the past few years in our practice there have been many cases when the compensation amounts reached up to 5 million rubles, that for small and medium enterprises may be the fatalic numbers, and they will have to close their doors. So the recommendation is as simple as this: to always check the trademarks that similar to those brands that businessmen want to launch. So another problem is not to register the trademark. So this is the story that is linked to the fact that many businessmen manufacture some products themselves, and they invent the names of those brands themselves. And now, because there is a huge competition in the marketplaces themselves, the competitors, the sellers compete by getting positive reviews for their products that are stored in the cars, and then this products are ranged. The more there are positive reviews, then the more likely that those products will be bought. And if such a situation happens that the card is blocked, then all the accumulated reviews and points are lost, and a businessman has to start the business from scratch. And many people ignore the story of registering their brand as the trademark, because it seems to be very long, or it seems to be very costly, and it's better to spend something for marketing or something else rather than increasing the costs or incurring the costs. But this is a fatal mistake, because there are some people in the market, the so-called the patent trolls, who track the brands that have become popular in marketplaces, and if the trademark is not registered for this brand, they make use of these brands, of these points, and start terrifying the good sellers, because they don't have the patent rights. But they have patent rights, but the seller doesn't, and the only thing to deal with that is challenging the trademarks and depriving them from the trademarks, because they don't use it, and it takes time, because it can be only done through the illegal proceedings, and sometimes it may take half a year, but one needs to sell products right here, right now, and sometimes it's not pretty successful, because such cases that you can see in the slide, in one of those cases, despite the fact that it was pretty obvious that Batulin was the patent troll, nevertheless, it was not possible to prove before the court that he violated, and a fair businessman could not continue his work because he was prevented. So the recommendation is always to submit the request on time, and it's just in tune with the previous point that and these trademarks must be verified, and you need to register them as quick as possible. It doesn't cost fortune, because these services can be easily used. Well, and the last point I'd like to talk about is the mistake of not tracking your competitors. If everything was fine for the first point, the trademark is registered, the sales are going on, that's extremely important to avoid that some third parties would take advantage of the popularity of the trademark and sell products under their mark. So, okay, how you can do that? The easiest way to do that is to use the standard searching engine, as it strange may seem, either in the browser or in the marketplaces, where you can use the name of the brand and find someone to find who these people are, what those people are doing, if they are not the right owners, and then you will be able to claim from them and ask them to hide these things. This is pretty costly and not efficient. For example, Ozon is a platform that seeks to help right owners to protect their rights and improve the customer experience and make people trust what they find in Ozon. We created a special service as the brand personal account. What is it? This is the personal account that any right holder of the brand can use, and once you register, when you provide the documents, you don't want to be the seller in the marketplace, you can only be the right holder, and if the documents are proven to be verified, and the right owner in his service will be able to see almost absolutely all the products where his trademark can appear, and such in this way you can easily analyze all this information. You can check what sellers sell what products, and in the personal account you will be able to see that if there is a document of the right holder whose rights are violated, then you will be able to submit the claim, and the product will be blocked. And that's extremely useful. It improves the relationship of the right holder with the marketplace, because you will never deal with sending the claims by email, waiting for the time when they are dealt with, and that's pretty seamless and it's simple. Every year there are extremely more right holders who are using this service, and we are thanking them for it. So there is a key. The finding is simple. You need to do the monitoring and use all the tools that the platform provides to protect your rights. Well, thank you for that, and that's it from my side. I'll be happy to take your questions. Well, thank you very much, Maya, for your presentation. I think that you managed to answer many questions from the audience. Probable doubts have been cleared, and now I'd like to hand it over to Jusan Mart and ask if there are some questions from the audience. Yes, please, go ahead. Maya, good afternoon. Uh, my name is Afonova Yekaterina, Chingenka company. Just tell me, please, in Russia there is an option for right holders to create the right holders account and track those sellers who sell the products. And what about Kazakhstan? If we create kind of an account here, will it allow you to track, to monitor the sellers in Kazakhstan, or should it be a separate right holder account where he can check the right holders here? Okay, I understood your question. Meanwhile, our account is only working for Russian right holders in relation to Russian products, and in case if a person works in Kazakhstan and he has the registered trademark in the Russian system, then this means of protection can be used. But in other countries' jurisdictions, our account is not working. But as the business is developing, such option should appear. Well, thank you very much. Okay, colleagues, do you have other questions? Other questions from the audience or online? I'd like to. This is what I want to remind. Yeah, we are a little bit ahead of the schedule. I didn't know that the questions can be asked online. Okay, we have more than 20 listeners online. Okay, Maya, thank you very much for your talk. Oh, well, we also have one more speaker. Oh, yeah. Okay, a little bit later. Let's do that a little bit later. Okay, let's keep it open because we have another speaker. Maya, thank you very much for that. Thank you very much for your talk. And now we have a small Malik Itzhai will speak. Malik is in the audience as far as I understand. And on that, we will have 10 wrap-up minutes before we end our section. And meanwhile, myself and Maya, we mute ourselves. Good afternoon to everyone. My name is Malika. I'm the chairman of the smoking market of Kazakhstan. So today, unfortunately, in the field of e-cigarettes and e-nicotine, they can be used in multi-use or single-use devices. We unfortunately encounter a big number of fake products, and these fake products are spread mostly on the internet. Well, e-cigarettes they have certain risks, exposures for the smokers, and the devices themselves, they appeared in the market in 2013, and they are really appreciated in the market, and this can be seen and this can be heard on the news. People say that it has a negative impact on the health, especially for the youth. And our problem is that there are many fake products in our market, and despite the fact that the brand itself is not original, the unfair businessmen bring these devices to the market, and the liquid itself may be of a poor quality, of not of the content that is in the original product. And the other problem is the accumulators, those exposures of batteries happen because of the fake products. We as the association are fighting with this, and we have certain challenges with internet sales. Let's consider Walt or Glover. A person can order the device here and can be fake one. So on 30th, on December 30th, there was a request on blocking these products, but the ones who distribute this online, they don't use online e-labeling, and the ones who have physical sales points, they turn to that, because our association works in a way to certify our businessmen for their fairness, and we will call on all people to work officially. But unfortunately, still we can't fight with the dark sales. And Telegram channel has at least 20,000 wholesale sellers of those fake products that are marked. There is a small number of marked products. Well, our association launched today their own checks. We rewrite claims, but because those claims are sometimes ignored, we are hopeless. And the customs is a difficult thing to verify the imports of all those products. These are the agreed amounts of those. 40% of the products are fake products, and this is the problem that we have with electronic nicotine system with e-cigarettes, and we are only fighting with it with the use of law enforcement agencies, and we have big problems like Volt, Glovo, where people can easily register and such products can be easily delivered. Besides, one of our proposal is to forbid the delivery of cigarettes or any other excise products, just not to order them through Instagram, Telegram, or any other marketplace. Because first and foremost, there is a limitation in age 21 plus. The ones who are not of this age, they can't consume those products, and you cannot verify it online. And the talks on verifying these products is still there because of unfair manufacturers. They used to be exposures of batteries and sales to the minors. This happened because of the products. I apologize to wait a little bit, and at the same time I would like to remind to all the participants, and especially for online ones, that we have a chance to ask all your questions online, both to the speakers and other participants through Telegram channel IP/Telegram underscore Telegram channel. There are two posts for the questions, and the questions can be asked to the posts. Okay. So let's get started. This is the last session today, and it's called Transboundary Copyrights, where we will talk about our vivid and very important questions of the protection of the copyrights. And one of the speakers in this talk is Katerina Sheffer. She's the managing partner of INTA, intellectual property rights. She is the patent attorney. She deals with the patent issues and trademarks. Okay, Katerina, the floor is yours. Good afternoon, dear participants. Could you tell me, please, if you can see and you can hear me well? Thank you very much. Perfect. Fine, that's a great pleasure for me to attend this event, unfortunately online, because we were already talking with our colleagues that in our challenging times we need to visit each other, see each other, because we haven't seen each other for a long time. Well, I want to tell you that the practice of cost recovery for violation of the intellectual property items is being very strongly developed, and today I'd like to share with you our latest trends. At the same time, Dmitry Markanov planned the meeting in Novosibirsk. Next week we hold the event there dedicated to the compensation within the Siberian Economic Week. But today I would like to share with you some of the things that we face in our practice. Well, I know that in Kazakhstan and in Uzbekistan there is a problem of trademarks, trawlers, and risks, and probably we will find different ways to be useful for each other, and probably we'll have certain ideas in this respect. Okay. And today I'm not alone who will be presenting, but also I have a partner from Patent, Valeria Belova. She will share the specific practices with us. She will share the statistics from the marketplaces, and she will tell us the way the practice is evolving and how the statistics may use for the compensation. Okay, the compensation has a dual nature. First, it recovers the cost and losses, and on the other hand, there is a discussion among the civilists that is it recovery, status recovery nature, that it recovers the status, or should it be the punitive of a punitive nature? That's why the discussions are always there. There is no single opinion about it, but I think that it may be of dual natures. So in the Russian legislation there are three types of compensation, from 10,000 to 5 million rubles, and there can be the dual increase in cost of the right compensation that are imposed, that are recovered in the court, and dual 2 times recovery of the cost of the fake products. It does not apply to the patents and prototypes, but the previous models apply everywhere. So, and what we are doing now, what the courts are dealing with now, they are searching for a balance. On the one hand, one needs to recover compensation to avoid fake products, and today we were talking about this the whole day. I haven't heard all the reports, but I have heard some of them before. In order to stop fake products dissemination, we need to prevent from the unfounded recovery of compensation. And what the courts are doing, on the other hand, they want to recover costs from unfair businessmen, but they want to avoid that the compensations become business, the recoveries to mass to mass right holders, to mass claimants. There are 5 legal cases against the different buyers, and this situation for fair enterprises is not good, because they are caught for some small omission, for them some small case, and they will be punished, and they should not be punished. And when it comes to foreign right holders, the foreign right holders are litigating with each other quite often. They may have different representatives, and they keep on defending their rights. And this happiness of Russian unfair right holders, it went down. The court said that there is that the rights will be not protected. Nevertheless, the rights of the foreign companies are respected. So there is a fixed compensation for every violation. There can be a compensation. What can be the compensation? So the person is found innocent until his guilt is proven. So there can be indefinite number. in the different number of characters in the movie, and what kind of compensation can get the right holder for one film or many characters in this film. So there is a thing it is being considered in the courts in a different way. For example, in VAV, you can get a separate compensation, but for the series in movies or the film, the court will recover one-time compensation once without thinking that different characters and different series and they will be considered as one-time violation, and sometimes a number of different items are in one. It is all considered as the violation until it's proven that this movie is this figure is taken from one source and there is only one violation of copyrights. But if the right holder has different trademarks, the same happens with smeshadics. When one character has one trademark and the other has the other one, then it's gonna be two violations. Sometimes it happens that for one name there are multiple trademarks. There are big companies that use different trademark for the logotype, for the name, and for the image, and for the for something else, for the motto, three different trademarks. So there can be one item, and in this case the compensation will be recovered only once. In 2018, the Supreme Court's ruling number 10 provides for the whole section of the intellectual property rights protection, and that's why we quote it in all the cases. And the interesting case here that are being actively used. The first item is 56 about single economic purpose. So what it means if the same people were selling the same product, they will have one violation until they bring this product to the consumer. The storage, transportation of the products until the seller can be qualified as one violation. And just recently, in September 2023, the Court on Intellectual Rights spoke and said that these things must be taken into account. And on the other hand, there are some cases when multiple products were sold by one seller, and it means that if one seller sold multiple products, the batch of 1,000 pieces, then in this case this does not provocate multiple multiple problems. If he bought this product once and if he sold it across multiple points with its action, then in this case it will not be a problem. There won't be 100 violations. There can be only one violation that is given in the ruling of the court. So the ways to prove it, well, this is what it comes to the compensation of up to 5 million, and how to prove it. There are different ways how to prove the cost of rights. When we try to prove the rights, when it comes to the trademarks, here you can use different tools how to prove the rights for the situation. The courts are actively using the evaluation of rights and licensed payments. This is the tool that can be there, that can take place, and the licensed agreement might be used that enters into force for the use of trademark. But here the courts understand that such licensed agreement can be purposely entered into, that can be applicable to the court, and such options studied. There is a constitutional court a ruling that has a certain phrase at the end of this of this ruling, that it does not diminish the necessity for the court to study the case itself, the details of the case, and the agreement that was signed and entered into by the right holder must be studied by the court to understand to what extent these circumstances are comparable with the other ones that can be there, that can be applicable. And another thing is to prove the cost of fake products. When the compensation is claimed equals to the cost of the products, so in this case different tools can be applied. And on the one hand, there can be only this distributor, and on the other hand, the system can be different. The reference system for recovery of cost. One of the system will be explained by Valeria, and this is not compulsory that these systems can be applied to marketplaces. The marking in the Russian Federation is being actively used. There is a system that is called Fair Trademark Mercury for food, for other products, and it's an easy way to prove the size of the violation. It's easy enough to enter into this reference system and find the information. And before I hand it over to you, I'd like to refer to the Constitutional Court ruling that the compensation must be equal to the size of the damages. And sometimes the damages must not be proven, but nevertheless the right holder should give the proofs of the costs and his expense that he incurred. That's why there are different aspects, and the courts now know how to take into consideration different factors. And partner Valeria below will talk more about it. Good afternoon, dear colleagues. I hope that you can hear me. In parallel, some renovations started in the neighboring apartment. Yes, we can hear you well. Okay, so good afternoon again. Thank you very much for this opportunity to share my experience. Well, it was a great pleasure for me to talk to you and to discuss the story, but it's pretty relevant in our practice too. We will be talking with you about the size of the compensation when we talk about the internet trade and when there is a need to prove the volume of fake products in marketplaces. It's all clear that many of the sellers are aimed at online sales, so that's pretty relevant. Online shops emerging from time to time. There are some participants like Wildberries and Ozone, and I want to concentrate on them, and probably this is just the beginning. Okay, about the case, if we need to prove the volume of fake products in the marketplace, how can we know that this volume of fake products was sold? So in our case, we can use a certain system, MP-Stats. MP-Stats was developed by Skolkovo. If you find this program on the internet, if you read about it, the way they deliver themselves, that's a service that will demonstrate the sales volumes in Wildberries, in Ozone, the monitoring of prices and sellers in the marketplaces. So if you look at that and if you see the statistics in the next slide, you can see that, as a matter of fact, it represents such a complicated table where you can see the seller. You will be able to see the sales technique. I will be talking about it later on, the way the prices changed and what kind of stocks this cart of the sales has, and this information can be further spread. This service is not free of charge. You can get an access for a fee. So what I can tell you about this service? Well, I believe that in my practice I faced such statistical data, both from the claimant and defendant. And I don't believe that this is the only possible way, but nonetheless, after a certain analysis, I can tell you that when this service can be useful for you, and I will tell you about the challenges here and how you can use it. We really care the way the courts treat the statistical information. And in the slide, you can see that the courts acknowledge this information. They find it suitable, and they consider them as the proofs for the case, and they use it if we need to quantify the volumes of the products. And to use the system or not, there are two key factors. The first factor, like I told you, there is the so-called sales systems, and another thing is that you have to, from the claimant court, to prove the. So first is the sales system. So this there are two sales system in marketplaces from the seller. The so-called abbreviation FBO and FBS. FBO is the system when the seller fully submits the products to Wildberries or so on, and FBS is when the seller uses his warehouse. That's a principled matter, because there are some matters taken from the judicial practice. In the Russian system, there is an understanding of those matters, and if you look at this card, the statistical information, and if we see that the seller uses a FBO system, then NPSTATS system is a good one to be used. So what's the reason for that? Because you will be able to see the data on volumes of the products that were set by marketplaces based on the acceptance of products at the warehouse, and we understand that there are certain sales reports that contain the quantity of products that have been sold and paid to the buyer, and this statistics goes through the paper flow, and he will have to. The seller will have to provide the full nomenclature of the documents, and the prices will be diverging in a minimum way. So if you talk about FBS system, one should note that the small and medium enterprises often prefer this marketplaces system because there are less movements, and your own in-house warehouses are enough. And that's why the volume on the products is provided independently. And given the fact that this information is, as a matter of fact, is not proven, you can easily be driven by the volumes of fake products by simply saying that these figures have technical mistakes, they don't reflect the merging or separation of the products from different warehouses, and there is no proof that this much was sold, etc. And if the defendant gives the counter calculations, if the respondent proved his report not only with the figures but also with the documents that he delivered them in the volume that is needed, then InfoStat can be seriously criticized. I would like to remind you about the timing. Well, in this case, I would like to not to be driven simply on this system, but to use it as the additional one. This is it, what I wanted to briefly mention, and now I'd like to come back to Katerina. Thank you. And just to conclude our presentation, I'd like to tell you that there is a special draft of law in Russia with respect to the civil code, that our civil code is not constitutional, and meanwhile this law was only adopted in the first reading. There are many criticism, and you can see the link in the presentation. It exceeds the minimum threshold of 50,000, and it also refers to the threefold recovery if there is a violation, but at the same time it provides for the way how to do the right calculation. So our contacts and the link to Telegram channel are available in this QR code. We are ready to answer all your questions. Thank you very much for your time. Well, thank you very much, Ekaterina, for your talk. Okay, I think colleagues will find your topic pretty interesting, because in Kazakhstan the legislation provides for the compensation for the use of illegal use of trademark, but the size of compensation in Kazakhstan not defined, not with the lowest, not with the highest range, because the sum of the compensation definition is referred to the court. So for some positions, but not always, because of some factors that are not always suitable for the nature of the violation and the cost of the original product. Well, this is not always the fact when there is a legal use of the a trademark. You cannot always compare the fake products with the original one. The manufacturer of original product may not have such a type of original products like the manufacturer of fake products produced, and the market price of the fake products cannot always be defined. In 2018, this amendment was made to the Civil Code of the Republic of Kazakhstan, to the item 6 of the Article 1032, and at that time some of those initiatives were offered of introducing the lower and the highest limits of the compensation, but the Russian colleagues said that in Russia the right owners are pretty active and pretty aggressively use this norm, and they file a claim against the offender and of the copyright, even if he sold only one piece, in order to at least gain some money from him, thereby filling their pockets with money. I think this is the separate topic to be discussed. Okay, and let us continue. Okay, our next speaker is Anna Grivtsova. She represents the Agency of Intellectual Property, INTA, and she will be delivering the presentation of the brand protection from the boundary to the market. Anna, please, the floor is yours. Good afternoon, dear colleagues. Can you hear me? Can you see me? Okay, fine. Thank you very much. Okay, first and foremost, I'd like to thank you all again for this opportunity to speak. Thank you. Does it work well? Yes, we dimmed a little bit to see the presentation better. Okay, the topic of my talk is the protection of the brand from Banjuri to the market. So this is the system of interlinked elements. Each of them are independently important, and when you remove one of them, you risk to shake this system, and this system will be faulty and it will not work well, because you will not consider all other factors that can be there. And at the same time, I'd like to ask you the question now: do you know that only 5 of 100 brands that are included in the risk matrix of the Republic of Kazakhstan work well, work efficiently? No, I didn't know about it. Okay, this is the dialogue format that will be a little bit difficult for us to work, but okay, let's do it this way. Okay, I will answer to my question myself. According to statistics, it is like that, but it is a pretty sad statistics, and it happens. And why only one custom register is not enough for efficient protection of the products? We try to answer those questions, and we can use the presentation of Apple brand. Apple brand is one of the most luxury brand. Its evaluation in 2023 reached 297 billion USD is the worth of this company, and the company takes care a lot of the brand and pays all the efforts for it to develop, especially when you have to deal with fake products. And as far as you know, the fake products not only hamper the brand reputation but also leads to the consumer issues in his life. So like I told you, the company has one of the improved system for protection, and 75 countries of 75 custom service from 75 countries, and with the support of Apple, seized more than 4 million pieces of fake products. There were more than 2,000 raid actions, and Middle East 1,400 raids, and more than 1 million products were seized. So what allows us to reach such results? Such companies that are concerned with the protection of their brands and their their boundaries protection, registration of the trademarks in the trade registers of the customs union, and sometimes the author rights, copyrights protection. And this is about analytics that allows you to do the proactive work. So it allows you to do the purchases on the basis of online monitoring, and to perform monitorings, external monitorings, and gather information on the violations of all categories, from retail, wholesale, sale, and the producers. Everything allows you to provide information for cooperation with the state authorities, including with the custom authorities, within the use of the risks management that work not only in Kazakhstan successfully, but also in all trade union countries, especially on the territory of Russia. I would like to more detailedly speak on every portion. So what does safety of boundaries mean? We all know what trade register is. This is the register of intellectual property rights that represents the interest to protect the market from the fake products penetration or great products penetration through the boundaries. So I will describe you the way they work. I think the documents can be pretty the same. I don't want to go into details how it works in, like, for example, Kyrgyz Republic, but it seems everything similar in Russia. 2 or 3 years in Russia, Kazakhstan, Uzbekistan, and Kyrgyzstan. The fees are not charged, but in Armenia they are there, 20,000 drams. $50,000, and $20 in Kyrgyzstan, $15, and in Armenia $50. So like I told, the terms are more or less unified. You can include the trademark in the trade register by delivering the necessary documentations. It seems to be that all this system that has been working for a long time should function with the clear purpose. The right holders should get information and the trademarks must be controlled as they are imported to the territory. But at the same time, for it to work well, the trademarks must be well selected. And in here, you need to have a tailored approach for everyone. For example, when it comes to Apple products, out of all the trademarks registered on the territory, the first the umbrella brand was found, iPhones or iPads, and but as a consequence of working in the external market, we complemented the tax register with some other trademarks. And the reason why it happened is that an important role is played by the analysis of fake products that you find when you interact with those. I would like to give you the practice from the September 2022. There were two signs, and after September, when we launched the active monitoring of both online and offline sphere, we found the products with such products like Lightning and AirPods, and we decided to put these markings in the register because the names were not given by declarants, by applicants when they brought this territory, the products to this territory. So this way we managed to optimize the work of customs within such interaction. So in order to protect ourselves in the market against fake products, the key thing in here is two components: online and offline monitoring, like I already mentioned, to search for factors and analyze this information that you get from it. And another good thing would be the alignment of efforts with the sales team that knows how what the internal market looks like, what are the issues, and what one needs to take care of, where the brand has weaknesses, and what kind of violations are serious ones, and what kind of strategies can be used dealing with that in Kazakhstan. The tools I'd like to reflect in my presentation for Kazakhstan, they can be here in full. That's why we also provide for all possible responsibility, civil, administrative, and criminal responsibility on liability. And the most positive thing of fighting with fake products was residing in the fact that there was an event that in the year the unscheduled inspections of small and medium enterprises were allowed within the business code of the Republic of Kazakhstan under the decree of the President of September 7, 2020, that allowed to intensify the work of this in the internal market. We managed to involve the Minister of Justice, who is authorized in the Republic of Kazakhstan to perform planned and non-planned inspections. So the online monitoring allows for the improvement and searching for the violations on the internet. And the ones who find their responsibility can be brought to civic responsibility, and by using the compensation mechanisms that are pretty frequent. And many of them use those mechanisms to protect the brand health, and these processes not only decrease the cost but also allow others to earn money, because not only right holders have this right. Some of the brands are popular, and this strategy can be used. The extra effect, if the right holder performs this tool systematically, is the chance to gather information from the retail with the use of the checks in the internal market to its suppliers. And if we hold this work in a comprehensive and a complex way, in an integral way, we will not only be fighting with small players, but we will be also focusing on big infringers, and we will deliver this information to the authorized bodies who will be able to deal with that. So if the recourse to police will allow you to fight with fake products in the production. So cooperation with the law enforcement agencies and interaction with the investigation bodies must be a permanent, constant factor that the right holders should keep in mind. And the support must be given from the entities. That's why, for these purposes, both in Kazakhstan and in Russia, as well as in other countries, there can be the 24/7 support for efficient sharing of information with the Ministry of Justice. It may take several minutes, provision of necessary documents. We perform different surveys, the expertise of products in Russian Federation, and the practice with expertise is not that well. But within the administrative proceedings, it allows us to gather relevant information with the proof that the products are considered to be safe. We can also be involved within the administrative violations, and we can attend to the court hearings. At the same time, I would like to mention the positive experience interacting with the law enforcement agencies in Kazakhstan. We like the speed of dealing with these cases. We have successful stories with the Department of Justice in Karaganda when seizure and destruction of products took in 2 months. For every country, that's a record indicator, and we would like to thank the Ministry of Justice for their work. At that, I'd like to conclude. I have half a minute, and I'd like to tell you that the concept described has been used in many events, in football championship, in Olympiads and others. Not only in the large companies may use this strategy, but it is available for every right holder. Here you can see the examples of what you can use in your work, and undoubtedly, if you need every support, we will be able to contribute in this regard. Thank you very much. Thank you very much for that, Anna. You have applause from the audience. Yes, the brand protection must be structured. This is long work. It lasts for not more than 1 year, and it should not be apt if the company does not want to lose the market where fake products will appear. And now I'd like to hand it over to our next speaker, Umurgul Balpanova, the legal company partner at Kyrgyzstan. Umurgul, she's the patent attorney of Kyrgyz Republic, and she will speak on the topic of the intellectual property rights protection on the customs of Kyrgyzstan. Umurgul, are you with us now? Yes, I'm here. Can you hear me? Yes, we can hear you. Well, thank you very much. I'd like to welcome all the participants of the roundtable, and I'd like to express the words of gratitude to the organizers of this roundtable for this opportunity to speak with my presentation. May I start sharing the screen? Can you start sharing the screen yourself? Sorry, can you hear me? Can you see me? Okay, fine, perfect. Yeah, we can see your presentation. Sorry for this technical trouble. Just a couple of words about the company that I represent. I'm the partner of INTA legal company, and one of the strong emphases of our company is intellectual property rights and provision of all services for that purpose, getting patents for trademarks and their defense in the court. Moreover, we follow up the transactions with the intellectual property items, as well as we are actively involved in the lawmaking in this sphere, and we are actively involved in the outreach campaigns. So we are the part of different trainings and seminars. So, and a few words about small historic background. Kyrgyzstan is a country that was the first one among the CIS countries that has become the member of International Intellectual Property Rights Organization. And the code that was adopted in 1997 provided for the provisions that are given interest in this agreement. And because Kyrgyzstan is a member of Eurasian Economic Union, we also provide for the respect of the code of Eurasian Economic Union. And you can see in this slide a number of improvements. The laws were adapted that had special chapters dedicated to custom clearance, and now the law in the edition of 2019 is acting, despite the fact that the law was adopted in 1997. The first trademarks were included in the register only in 2010. And a few words about statistics. So the intellectual property rights register included 2,000 trademarks, and 237 trademarks are valid as of today. Nurgul, could you tell me please if we need to switch to the next slide? Here you can see the scheme. Here you can see our national scheme of intellectual property rights protection. It was based on the typical legislation that was developed by the World Customs Organization. It was mentioned today. You can see the scheme. The right holder should go to the central customs body with the application, and then the authorized body should review it, should send the information to the customs points, and then they should check where this documents stack, and the measures should be taken to protect. So in the next slide you can also see some of the words that many people were talking about it today, that the intellectual property rights are the rights. Apologies for interrupting you. We see the slide of inclusion of TRIIS into VIPO. No, that's all fine. That's all fine. That's the next slide. I will turn to that. So the protection and the measures of preventing importation of fake products. So it can be done with the use of recourse to the authorities, and for that you will have to have you will have to go to our GDS and provide the necessary information and documents. The term of protection, like it was mentioned, is 2 years. Okay, next slide, please. Okay, next slide. The review of the application. So the application must provide for the commitments for recovery of costs in case of suspension at the border, and you need to provide the agreement of insurance, and the insured amount must be at least 7,000 master calculated indices, around $80,000. It is recovered like in other countries. Such a levy is not provided, and sometimes there can be recoveries for extension, and it depends on the term. So the review date is 1 month, and you have a chance to extend it for more. So we have a practice that the customs use it for a longer period of time, and these applications are reviewed within 3 months. Okay, next slide. So the suspension, it was also the norms of the international treaties was taken into consideration when the rights are halted. The suspension is 10 days, and if there is a request, they can be extended for another 10 days. And the right owner should take measures to protect his rights, and for that he need to go to the court. And we only have one option, is to go to court. And as a balance, if the right owner does not take the actions, the products are released in free circulation. Okay, next slide, please. So, and we have a small judicial practice for such cases when the fake products are halted. So the first group of the cases were related to the pharmaceuticals. So the reason why I'm highlighting it is that the cases, the fake products were not equals, but very similar to identity, but they were homogeneous products of class 5 pharmaceuticals. And practically almost all our defendants commended it that they are not the manufacturers of those products. By the way, those products were imported from China, and they told like go to Chinese manufacturers. And because this we refer to but because we refer to the law on trademarks, it was written that the not only the manufacturing but the import is the violation, and the court thereby supported our position. Next slide, please. So in the next slide you can see the judicial lawsuits related to the alcoholic products, and they were also related to the parallel importation, and the defendant tried to reason that this was about the original products, but the right owners said that this import was not sanctioned, and it was considered as the violation. So they have exclusive licensor. He was that's why there were courts, and the courts proven the parallel importation and the violation of rules of Kyrgyz Republic. And here I mention that so there are countries that are the stakeholders of the Eurasian Economic Union. Okay, next slide. So this problem was related to the product of the famous sport equipment manufacturer, and the batch of sport products was halted, but the court satisfied the lawsuit, but the defendant did not agree on that, and it even reached the Supreme Court. They said, like, we cannot delete the labeled trademarks, give this product to us and we will rectify. We couldn't help but agreeing with this position, and we told that the destruction of fake products are the prerequisites of defending the trademark, but nonetheless, the simple deletion of these faked numbers was not legitimate. Because there was no chance to consider to provide for the risk that the violation will continue, despite the fact that we will delete these labelings. So in the next slide, I'd like to summarize that the custom measures are not that efficient, and today our colleagues share their cases that the boundary measures are the barriers of appearance of and entering of fake products to our countries. Of course, it is easier to fight with these violations. So it's easier to control when the products enter the market. So the right owners should be active. They need to cooperate with the law enforcement agencies and with the with law enforcement bodies that are efficient barriers in our country. And because I mentioned that our company is also active in lawmaking, this year there was an attempt to amend our law on regulation. There are many norms that would harden the inclusion of such norms. And there were many of them, and I believe that one of the principled amendment that should have been included. If I'm not mistaken, I don't know if it was accepted or not, but we didn't allow it. One of the prerequisite of being included in the customs register is the provision of the documents and documentary proofs that the product sign was violated, despite the fact that the law suggests that other measures can be involved, geographical naming of the products, etc. It happens that in our tax register the trademarks are included. That because of the fact that our company is the chairman of the Committee of Intellectual Property and Business Council, we, as the voice of business, we were contacting two deputies, so we presented our objections and we proved that such amendments are not affordable, and they supported us and they were cancelled. This is it from my side. Well, if you have any questions, thank you very much. Thank you very much for your talk. Now I have one question here. Just tell me, please, in case if the products are suspended, does the suspend take 10 days? Doesn't it, or can we extend for 10 days more, and what are the prerequisites to do the extension? Well, if you need to take samples, if you need some time to analyze it, and do people go to court with the lawsuit? No, you don't have to. In my practice, it happened when we just asked that we were in Japanese holiday in Japan, and the products were halted for Japanese holder, and unfortunately it turned out that we cannot contact because of the holidays, and we received the instructions from the holders, and we provided a copy of lawsuit, and there was the legal proceedings, and we also have the questions from telegrams. So, as a matter of fact, there was a dialogue in Telegram with respect to the previous speaker. Just tell me, please, why introducing in today's is 3,500 sum and extension is more expensive. If you open the slide with the legal regulation, if you come back to this. You could see the law, and the law provided for this provision of including the intellectual property rights there. And in this provision, in this resolution, 1,300 sums for the inclusion and 1,000 sum for 300,000 sum for extension. And when amendments of the law were considered, it included the size of levies for registration and extension. I think that during the review examination there were observations, and we were told that this issue should be regulated by the government. That's why the initial inclusion, it was written that it's said by the government, and the extension was skipped. And in the law, it remains in a higher volume. The 5,000 sums are provided by the law. And okay, then we are silent. We don't mention it. Okay, yeah, this is purely the technical stuff. Okay, thank you very much, Nurgul, for your talk. Okay, colleagues, we have 10 more minutes, and I'd like to take this right as a moderator to speak and to deliver one presentation, if you allow me. So we didn't have that in the program, so this is a surprise for you. Just a small problem related to the criminal cases. The criminal liability for intellectual property rights is provided for the violation of authorship and associated rights, for the violation of patent rights, and for the illegal use of trademark and trade name. So in here I'd like to dwell on one practical problem, the illegal use of the foreign trademark. So the criminal code is being regulated by the Article 122 of the Criminal Code of Republic of Kazakhstan. And here you can see the disposition of this article. The sanction can be provided with fine or some penalty works and even arrest for 20 days. So the essence of this phrase, the illegal is the use of the foreign trademarks if this brings huge damage. In order to understand what huge damage is, we refer to the article which is called the explanation of certain concepts used in this code. And according to the article 222 of the Criminal Code of the Republic of Kazakhstan, the large damage is the damage that is inflicted by a person that is 200 times more for the MCI, or for the organization that 2,000 times higher than the monthly calculated index MCI. It seems all to be clear, but what means the damage of a company that 200 times higher than monthly calculated indices, which is almost 7 million tenge? What it is? This is not the loss. But this is not the loss. This is the damage. Could you talk to the mic, please? Well, let me continue and then I finish, okay? So, for example, there is one case. The case is being investigated. A big warehouse is found with fake products. It was found that these products are not only stored but also packed. There is a partial partial assembly of this product. This product is delivered to the site. It is being sold to different sellers accepted the analysis of these fake products, are checked, additional storage areas are found, the additional products with different names are found. Then the legal proceedings start. Someone asked about the practice. That's the whole story. The inspections and investigations are performed, and these seize in one place took 20 hours, and seize operations took place in 20 places, and then the products are seized and taken out. You can see here separately. Sometimes the products are delivered separately. The packaging is there. It is all packed and delivered to the market. I demonstrated you how it works. So as a result of this raid, 106,000 spare parts were seized, and the total damage of one company was 1.6 million USD. So more than 1,750,000,000 tenge. So practical use, again, the practical use and about the damage. So this is the extraction from the court ruling, despite the fact that those products were used without the consent of the right holders. The market the market value will be by the damage, the inflicted damage, but the court says, oh, but these products were not sold. You seized these products, you confiscated them, you taken them out, and the ruling of the court is pardoning, calling B and T as innocent in criminal code. There is, on the one hand, that much of money and the innocence of those two individuals. And the Supreme Court said that those products were not delivered to sales, so they were stored in warehouse, and there cannot be any infliction to those who sold that. Who didn't sell that, sorry. And the decision of the court, the ruling of the court, stays the same. And what the criminal code says, the criminal code provides for the large fine for the violation of author's right and associated patent right. Article 198 and 199. So what is the damage? What the damage? The size of the damage, or the cost of the rights of the use, the licensed payment, the rights of payments of the intellectual property rights, and most importantly, the cost of the copies of author rights or patented products. So you see the difference in here. So when we talk about the author's right or patent rights, so the court is entitled, and the investigation is entitled as a damage to be guarded by the price of the copies. And when we talk about the trademarks, it cannot be the case, and the investigation should prove to the prosecutor's office and to the court that the offendant sold this much from amount that exceeds 7 million tenge, and in this way we have the discrimination of the product and trademark owners towards the right holders and trademark holders. But the department related to the trademark, the patent rights where there were 0. For the trademarks, only 16 criminal cases known to me last year. So the reason why the right holders of the products are in the unequal position. This is not it does not come to us. Well, we need to bring the damage for the violation of the copyrights in line with the large damage with the violations of patent rights, and there should be amendments. There should be amendments to the criminal codes, and recently these amendments were sent to the government for further review in the next session of Majlis of Parliament, and the lawsuit is being prepared. So this is the practice. Unfortunately, it's a negative one. There are many positive cases. I don't want you to be I don't want you to upset. There are things we need to improve, and I would like to apologize because okay, there is one question from the audience. So you told me that the amendments must be made to the legislation. Are there any improvements? Do you consider some options or what? So this is not the only proposal in the legislation that should be studied or introduced. There are some organizations where the patent attorneys are gathered, and some of them provided the proposals to the Ministry of Justice. And every patent attorney prepared their proposals, and the Ministry of Justice will accumulate all proposals, will develop the draft of the law, and will work with the authorized agencies and with the prosecutor's office, and there will be a package of amendments that will be sent to the Majlis of the Parliament. If the things go well, how long will it take? In 2016 we initiated similar amendments to the legislation, and this set of amendments was adopted in 2018. I think we will have 2 years to reinforce it. And okay, Tatiana has a question. So it turns out that these two manufacturers may continue manufacturing products because their guilt was not proven. So our today's event will be recorded, and I cannot answer you. I cannot give you either a positive or a negative answer, but we all understand that the violation of fake products is the violation. They were also the manufacturers, the producers, because they had a small workshop. And when you ask question about the judicial cases practice, it's ambiguous. So within this case, the government also provided for the revenue to the state, and we were fighting with the fact that these fake products would not go into the civil circulation on the one hand, and on the other hand, they changed the size to 2000 MCI. The size of MCIs was changing for some years, and the problem is before the public hearings under the ministry were created, the laws were proven by the deputies themselves without involvement by the society, especially the patent attorney and attorney intellectual property rights. And according to the law and the Article 222, you cannot recover the compensation. And the reason for that, because the courts only calculate the direct damage that is not the case. So we have a great deal of work to be done. Okay, colleagues, on that we would like to wrap up our session. So, Dmitry, are you with us now? Yes, yes, I'm with you. I'm with you. Okay, Dmitry, I just wanted to give you the floor for the conclusion remarks. And after your talk, the only thing I would like is to improve your to mood you up, saying like everything will be fine, don't worry, the situation will be improved, and those who are offenders will be brought to the criminal responsibility or administrative responsibility. There is a practice in Russia like this. Oh, okay. And to wrap up our conference, I'd like to thank all our listeners who have been the whole day with us online and offline, and I'm also sitting the whole day in front of the laptop, and I see that there are many listeners and they don't part. I hope that everything that you have heard will be very useful for you. And I would also like to thank all these speakers because the speakers are experts in their spheres, and if they are not experts, I believe that they have a huge wish to get involved in the discussion. And yeah, the best practices must be applied. I would also like to thank the organizers, especially Bolotov and Partners, and personally Yuri, and personally Janat. You have done a great job. I would like to thank all of you, and I would also like to thank INTA's colleagues who managed to join us today despite of the time difference. Some of us connected at 5 or 6 a.m. in the morning, and I really hope that our event has been successful, and I hope that we will repeat the same event next year, and we can arrange a series of such events. And I would also like to invite all of you to join or to review INTA's documents, to attend our yearly events with the involvement of the committee, and it's gonna be a very interesting, intriguing, and useful work. I would also like to wish you every fruitful business week that has just started, and I wish you to stay well, to be strong, and to eradicate the counterfeited products. Thank you very much, Dmitry. The audience is applauding you. Yes, today you have done a great job by waking up that early morning. Thank you very much, dear colleagues, for attending our round table. And I hope that we will accumulate whatever we have discussed today, and we will find the troubles, and upon the coordination with INTA, we will send you the resulting letter to the Ministry of Justice, either with proposals or just to report on the results of this roundtable. I'd like to thank all of you again, and goodbye. Have a good evening.